something from the books. It's taking me 4 minutes. I've been sitting here. I only want certain pages. It's on page 9.
Please make sure your electronic devices are set aside.
All rise. Court is now in session. The Honorable William Sullivan presiding.
Please be seated.
All right, all counsel, if you'd approach, please. All right, Ms. Merrifield.
Good morning, Your Honor.
Good morning, Ms. Merrifield.
Sit down.
I have 2 cases on the docket today. I'm going to take care of Mr. Marshall, Brandy Merrifield, on behalf of Robert Marshall and 25 CF 175. We have reached an agreement in this case, Judge. It is a plea in absentia, if I may approach.
Granted. Thank you. You'll announce the terms and conditions.
And Judge, for Mr. Marshall and 25 CF 175, he's withdrawing his previously entered plea of not guilty. He is entering a no contest plea. As I stated, it is an absentia. Count 1 is being pled to the amended charge of improper exhibition of a dangerous weapon or firearm. The statute is referenced. That is a first-degree misdemeanor. He'll pay standard court cost and cost of prosecution, probation for 11 months and 29 days through Judicial Correction Services, and it will be $55 per month cost of supervision and forfeit the firearm. As to count 2, that will be as charged, 11 months and 29 days probation through JCS as a misdemeanor. It will run consecutive to count 1 and $55 a month cost of supervision. This is a total of 2 years of probation as a consecutive sentence. He'll check in with JCS within 24 hours, and it is an adjudication withheld, Judge.
And that is the state's agreement. I see from the signature on the plea agreement. Is that correct?
That's correct, Your Honor.
All right. Madam Clerk, fines, fees, and costs.
270.
And the $55 cost of supervision, correct?
Correct.
Okay. Thank you very much, Ms. Merrifield.
Thank you, Judge. I do have one other case on the docket.
All right, go ahead.
Brandy Merrifield on behalf of Christian Rodriguez. It's 23 CF 669. Mr. Rodriguez is present. We're here today, Judge, on his petition to expunge his record That was filed on September the 9th, 2025. Has the court had the benefit?
Yes.
Thank you, Judge.
The state intended to reverse or demur the petition.
No, there's no legal basis for an objection from the state.
All right. Did you submit an order, Ms. Merrifield?
I did, Judge. I have a paper copy, but there is one also in the portal.
Second here. Don't see the order, Ms. Merrifield. If you want to pass it forward, I'll just execute it in paper.
Thank you, Judge, if I may approach.
Granted.
And that's all I have this morning. Thank you, Judge.
Thank you. Mr. Durrell.
Good morning, Your Honor.
Good morning, Mr. Durrell.
May it please the court, Dustin Durrell, Your Honor, my client today is Mr. Michael Lewis. And we do have a written plea agreement, if I may approach.
Granted.
Yes, Your Honor, at this time, Mr. Lewis would withdraw his previously entered plea of not guilty, enter a plea of no contest to count 2, with the understanding that the state is to announce an all pros on counts 1, 3, and 4. The sentence on count 2 would be the lesser included offense of simple possession of controlled substance. Sentence to time served, adjudicate guilty.
All right. And fines, fees, and costs, Madam Clerk?
Packet for 615, that's right.
615, okay. And is that the state's agreement?
It is, Your Honor.
Any score sheet objections, Mr. Durrell?
No objections, Your Honor.
Raise your right hand for me, please. Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
I do.
All right, you put your hand up. You heard what Mr. Durrell said. You signed the written plea form.
Yes,
How old are you?
51,
How much school do you have?
associate's degree.
You able to read and understand the plea form?
Yes,
Did you do that before you signed it?
yes,
And is what you read what Mr. Durrell just told me?
yes,
You understand you're pleading no contest to the announced charges?
yes,
And that tells me you believe the state has the evidence to prove your guilt and you're not going to contest that?
yes,
You understand by doing this, you're waiving your right to a trial by jury where the state would have to prove your guilt to that jury?
yes,
And in this case, you'll be adjudicated guilty of the announced charges and have since time served plus the costs that were announced. How much time do you need to get this paid?
Like probably about a couple months, 3 months tops. How much was it? 615, 615.
15?
Yeah, about 3 months probably.
So I'll give you 120 days just to give you a little wiggle room and to get that taken care of, okay?
Okay, thank you.
Mr. Durrell answered all your questions about the plea and how it affects you.
Yes,
You're satisfied with what he's done for you.
yes,
I'll find the plea to be freely and voluntarily entered into, and I'll accept the plea with the adjudication. If you'll step over this way, please. That's all from you this morning, Mr. Durrell?
For this morning, Your Honor, I do have one on the afternoon docket if I may address it. If not, I'll see you at, I believe
Yes,
it's
sir,
two-
go ahead. If you
It's
believe we
Mr.
can-
Tommy Lucas.
Yes.
The state and I do have
Just so
a,
we'll be sure that that's case number, you got two cases, 21, 2762 and 21, 2461.
yes, Your Honor. The state and I have reached a agreement that Mr. Lucas is willing to accept. However, we were not able to do it this afternoon, and I am out next Thursday. If we can have the court's next available date after that, I believe we would be able to bring this in for a resolution.
All right. State?
That's correct, Your Honor. We have reached a resolution. I'm good with the next available date, Your Honor.
All right, what date is that, Madam Clerk?
November 20th.
11/20?
Perfect, Your Honor. Thank you very much. Thank you,
All right.
Mr. Gomez. I believe that's all I have, Your
All
Honor.
right, thank you, Mr. Durrell. We'll remove that from the docket this afternoon.
Thank you very much.
All right. Who was that, Your Honor? Tommy Lucas. Mr. Gates. Good morning, Judge. Good morning, Mr. Gates.
Your Honor, I'm standing in for Cassie Reed. The first case that she has is Jonathan Ryan Smith, 25 CF 532. It's still on the docket, but there is a written plea to a misdemeanor that's been submitted.
And what, say again the name?
Jonathan Ryan Smith.
No, it's not one.
No.
What is your name?
Jonathan Ryan Smith, okay, which is 25 CF 532.
That's correct, Your Honor.
But you say we have a written plea?
Ms. Reed advised me this morning that written plea to a misdemeanor had been submitted, signed by the state.
It was filed on September 29th.
So that case should be disposed of, right?
It should be, Your Honor.
Okay. All right. Thank you, Mr. Gates.
And then the next case Ms. Reed has is Autumn Lusty, Lusty, 25 CF 378. If we could have the next a date for a control date, there's a written plea to a misdemeanor that will be signed and submitted.
And that's correct, Your Honor. I have spoken with Mr. Reed and we've come to that agreement.
All right. 11:20, Madam Clerk?
Yes, sir.
And that's all I have, Your Honor. I'll see you at 2:30.
All right, thank you, Mr. Gates. Good day. Pleasure to see you this afternoon. Mr. Flowers? Mr. Ufferman?
Your Honor, good morning. Can I approach with Ms. Herndon?
You may.
Thank you.
Your Honor, I appreciate the court's indulgence. I, as many do, had court in Defuniak Springs earlier today. Have two matters before you this morning, Your Honor. The first matter is Vaughn, V-A-U-G-H-N. Mr. Vaughn is present. And, Your Honor, with the court's permission, we'd like to leave that set as is. The state and I, quite frankly, have talked a great deal. We believe we have an agreement that we'll be able to just file prior to the next court date, the pretrial intervention agreement. We're so close that I cannot envision that won't be the case. So if we had a control date.
Do you want to set it just on the next cycle?
That would be fine, Judge. Judge, it won't be going to Mr. Vaughn. He's present. We've talked about it. We're really close. With a capital R, really close.
All right, and so that, Madam Clerk, next cycle would be
November 10th.
11/10.
11/10. Judge, that would be perfect.
All right, very good.
All right, I'll see you around this side, okay? Judge, the other matter that I have before the court, if I'm not mistaken, is Star. If we could have did 11/10 make sense for us to do the same thing?
Yes, try and resolve it this cycle.
We believe 11/10, we can resolve it at that same time, Judge. That's what we would anticipate, have no reason to believe otherwise.
So change of plea?
We believe that would be exactly what the court should anticipate.
Okay, all right. See, I'm
Your Honor,
11/10.
that's what I, Judge, with your permission, may I approach, please?
Yes.
Once again, thank you, Your Honor.
All right, thank you, ma'am. Good day. Ms. Jacob.
Thank you, Your Honor. Mr. Flowers?
Wait, okay. He's still going.
Sorry, Your Honor.
That's okay.
Your Honor, the first
Look out
time,
for each other. Appreciate that.
that's an important item. Whole lives are on those things. Your Honor, the first I have today is Michael Riley. The case numbers are on the docket are 25 CF 127 and 25 CF 189, but he also has a third matter, and I couldn't find that in the docket anywhere. I know sometimes it's still under Mr. Cochran or whoever, and it's just, but I
So what I
can't
show
find
is
it.
I have 25-217, 25-189, and 25-127.
Okay, so those are all three of his cases, but I didn't have that third one on the docket, so I just want to make
You on
sure.
board, Madam Clerk?
Okay, just want to make sure we're all on the same page and we get all the cases together. And Your Honor, in Mr. Riley's case, we just received the score sheet this week, and I did discuss that with Mr. Riley. However, we are looking into some other matters to see if we can get this resolved quickly, but at this point, I think we're gonna have to ask for the 11/20 date, and then hopefully we can get it resolved by then. And we'll enter a denial if one hasn't already previously been entered.
All right, so 11:10, 11:12, I guess it would be.
I actually think this is
Oh,
all
these
just
are all
straight
VOPs.
VOPs, yes,
These are
so I
all
think
VOPs.
Madam Clerk said the next date was November 20th.
11:20, state?
It's three cases, so all three cases are VOP cases, is what we're talking about. It's an administrative thing. You don't have to worry about that. You just don't have any new law violations, and that's what we're just trying.
All right,
Thank you, Your Honor.
thank you.
The next I have, Your Honor, is Russell Snell, 25 CF 1489 and 25 CF 1653. Katie Jakewood on his behalf.
Mr. Offerman?
From here.
Yes, sir.
Excuse me just a second,
Yes,
Ms.
sir.
Jacob. Mr. Barnes, it was here, just this was a lack of effective communication. If you wish, we can put him in the interview room real quickly so you can tell him the change of plans. And as soon as we finish Ms. Jaquith, then we'll call him to take care of it. Thank you.
And you'll just do the standard. Okay. Do you have any issues with that? Okay, and you got the one I sent you that had changed?
Yeah.
Okay. Thank you, Your Honor. Is the court prepared for me to, or is the court ready for me to move forward?
I am.
Okay, thank you, Your Honor. Mr. Snell has reached an agreement with the state. I'm gonna do it a little bit backwards because procedurally, we did file a motion to dismiss in 25 CF 1653. The state is going to null pros that case, so that kind of makes the motion to dismiss a nullity. So we will go ahead and withdraw that based on the state's agreement to null pros that case. As to the 25 CF 1489, he's going to be pleading no contest as charged. In count 1, it'll be an adjudication of guilt, 2 years of drug offender probation, followed by 1 year of standard probation. That will be concurrent to all their counts and cases. There is a $40 per month cost of supervision. We are going to ask the court waive that for a year. Mr. Snell is currently attempting to essentially take over custody of his children because the mother of his children recently had them removed by DCF. And on top of that, he's been in custody for the last several months, so he'll need some time to get out and get on his feet. There is $615 in court costs, $150 cost of defense, no controlled substances without a prescription with random urine screening, 50 hours of community service work. He is to enter and successfully complete the intensive outpatient substance abuse treatment and any aftercare they recommend. However, if probation is not able to get him into an intensive outpatient program locally, as my understanding is there may not be one available, then he will be allowed to do the standard outpatient treatment in lieu of that intensive outpatient treatment. There will be a 7 p.m. to 7 a.m. curfew. Probation will have leave to modify that as needed without needing to contact the court for work or school purposes. He does need to maintain gainful employment or show proof of 3 job applications per week. And the probation term will automatically terminate at 2 years if he's completed all the conditions and there have been no violations. Count 2 will be an adjudication with 2 years drug offender probation followed by 1 year standard probation. Again, that's all concurrent. And again, we'll have the provision for automatic early termination at the 2 year mark. Count 3 is a misdemeanor and will be adjudication of guilt and time served. We have no objection to the score sheet. May I approach?
Granted. Madam Clerk, fines, fees, and cost. Plus state-provided legal assistance. All right, and that's the state's agreement?
Yes, sir.
All right, raise your right hand for me, please. Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
Yes, sir.
All right. All right, you heard what Ms. Jaquith said, and you signed the written plea form?
Yes, sir.
How old are you?
I'm 27.
How much education do you have?
GED.
All right, you able to read and understand the plea form?
Yes, sir.
Did you do that before you signed it?
Yes, sir.
And it's what you read in the form, what Ms. Jaquith just told me?
Yes, sir.
Do you understand that you are pleading no contest to the announced charges?
Yes, sir.
And that says to me you believe the state has the evidence necessary to prove your guilt, and you're not going to contest that?
Right. Yes, sir.
You understand by doing this, you're waiving your right to a trial where the state would have to prove your guilt.
Yes, sir.
And you'll be adjudicated guilty and be on 2 years of drug offender probation, followed by your standard probation with the conditions that were announced, including finding employment or showing that you're making efforts to do so.
Yes, sir.
Ms. Jaquith answered all your questions about the plea and how it affects you.
Yes, sir.
And are you satisfied with how she's represented you?
Yes, sir.
And I'll waive the cost of supervision for a year while, particularly since we have the intensive outpatient program requirements.
Yes,
I'll find the plea to be freely and voluntarily entered into, and I'll accept the plea with the adjudication if you'd step over this way.
Your Honor, that's all I have this morning. If I may be excused until this afternoon.
Yes, ma'am.
Thank you.
All right, next we have the matter of Corey Barnes, 2002 CF 2198. Okay, yes, sir.
Good morning, Your Honor.
Good morning, sir.
Michael Uffman on behalf of Mr. Barnes. Mr. Barnes is in the courtroom standing next to me, and Mr. Barnes is familiar with the situation. I've filed a written motion to withdraw this morning, and Mr. Barnes understands why. I'd ask that you allow me to withdraw, Your Honor, and so as not to prejudice Mr. Barnes. I'm positive he's indigent, and he does have two claims that are before the court for a 3.850 hearing. I would ask that the Public Defender's Office be appointed to represent him.
State wish to be heard in any way?
Your Honor, the state has no objection.
I will, if you grant the motion, Your Honor, obviously, when whoever new counsel is, I will assist them in any way that I can.
I'm just editing your order to include the provision that the public defender is appointed.
Thank you, Your Honor.
Now, I will, and Mr. Cochran, you'll be representing the defendant from the office, correct?
Yes, Your Honor. We do have to do a conflict check to make sure. And as of right now, I will be representing him.
All right, so I'm going to go ahead and set another date, and the reason I'm going to do that is because otherwise he'll be transported back. And if I set another date, then he'll stay here, and that way your office will have access to him. And if you end up having a conflict, then whoever else ends up being appointed will have access to him more readily. And since the court's already made the determination that we should have an evidentiary hearing, there's no reason for him to be transported back until we can get the case set for that evidentiary hearing. So that's the method, so be sure that Mr. Barnes is available to talk to his new counsel and to move the case forward to disposition since the court's already made the determination that an evidentiary hearing is appropriate. That makes sense?
Yes, Your Honor.
So what date would that be, Madam Clerk? Let's choose And what I'll do is I'll set it as a status, and to be certain that if you don't have a conflict, then you can let us know if you're going to be in a position to go forward. And if you do have a conflict, then let us know as soon as possible so that we can, you see where I'm coming from. If it can go on to full evidentiary hearing, then we'll do that. And if it's just a status to move the case forward, just let the state know and let Ms. Natale know so we can be sure to keep the case moving.
Yes, sir.
So let's set it the first miscellaneous in November. Okay, 11:20. Mr. Cochran, right now, that's status unless you tell us otherwise.
Yes, sir.
Okay? 9 a.m.
Thank you.
Thank you, Your Honor.
Okay, and the order's in the queue. Okay? State, have you heard from Mr. Swiatek on Pilar Spillman?
He filed a motion to continue until, sometime in November. I saw it yesterday on raw paperwork.
All right, because my notes indicate the case in full would be continued to 11:10. But then we had a notice of hearing for a motion hearing today, correct? And he then requested a continuance on the motion hearing.
He did, so.
Any objection from the state?
No, sir.
All right, so it'll all be continued to 11:10. All right? Okay. Very good. Thank you. All right. So, Mr. Cochran, Mr. Koch, Mr. McKinney, I'll pass it to you, y'all.
Okay.
His date that he put on the notice of hearing is November 20th. Is that the date that you just continued to?
No, because the whole case is continued to 11:10, so, because
Okay.
that was for the next pretrial conference.
Okay.
All right.
I have one, but that's one.
Sounds like we'll be ready with the minutes.
All right. Yes. Yes. Okay, bailiff is, because we're overwhelmed in the back, bailiff is going to lay cue the inmates up in the order that is most efficient, so y'all just, I'm going to try and keep your brain cells flexible this morning.
I may need more coffee.
Exactly.
the red light, LIG.
Good morning.
Your Honor, I know this was supposed to be a plea today. There was some confusion between jail letters on what she wanted to do moving forward. So I did not retain a mitigation specialist based on a letter I received. I guess there was some miscommunication. I should have retained that specialist now. Long story, we're looking for a downward departure, Your Honor. And I can't do it without a mitigation specialist. And like I said, miscommunication, I thought she said she didn't want to go for the downward departure, and I misread the letter.
Okay.
So I need to get this.
All right. So what is the state's current offer?
Judge, state's offer is revoke and terminate with 24 months DOC.
Okay. And is that guidelines?
Judge,
or
that's a downward
above?
departure itself. She scores 37.2 months.
Why can't you ever come visit me? Because I read so many times, within the last month.
I know.
At least twice a month, so you couldn't come see me, so we
So
could clear up
the state's offer is 24 months, score is 37.2, so the state is agreeing to a downward departure of the 24.
Yes, Judge.
Okay. And so the defendant wants to provide additional information to the court, which could, she believes, convince the court to depart more than that.
Yes, Your Honor.
Okay, all right. And so if you'll get your order, I'll grant your motion. If you get your orders in as soon as possible, then we'll move the case forward. Do you want to set this for a control date on 11/20?
Yes, Your Honor.
Okay.
Hopefully by then, everything's done or moving.
All right. All right, very good. See you then. Thank you.
Because you told me the last court date that
I will get the expert out.
downward departure would kill the 24 months, so is that true or not?
If we get a downward departure and the judge grants it, yes.
Well, and I'll help you there, with Mr. Cochran. The different judges view violation of probation sentencing differently. My view is that I should look at the score sheet and I should use the score sheet in my sentencing. Other judges don't look at it that way. That's the way I do. And so I view it as in sentencing on a violation, if you are looking to go below the score sheet, then you should be presenting the same things that I would see in a regular sentencing. And the rules about that are as follows. The statute tells me the sort of things that I can look at to grant a departure, and there's, depending on how you cut them, you know, there's sections, and some people say there's 8 different categories, and some people say there's 6, but, you know, there's sort of subcategories, if that makes sense. But the statute says what those are. And then the statute says that you must prove by the preponderance of the evidence that one of those categories fits. And then you've got to show why I should depart. And so it's a 2-step process, that I can because you fit in one of the categories, and that I should because it's appropriate in the situation. Now, I'm a little more flexible in a violation of probation because I think I should be, because the probation statute says I should consider everything. So as opposed to a new sentencing where I'm very strict about that, I'm a little more flexible in a violation and look at, but I still believe those rules should apply looking at those statutes altogether. So that's the rules. First, you got to show you fit one of the categories, and 2, you've got to show why it is the best thing to be done. And that's kind of why Mr. Cochran is kind of not going, well, yes, because it's not just a simple yes or no question. It's this 2-step process, and it's your burden to prove, unlike most anywhere else in the criminal system, a departure requires you as the defendant to prove those things for the court to be able to make that departure. Now, the state's agreeing to the departure now at the 24 months. They don't have to, if you don't accept that, then they can say, no, we want a guideline sentence, and then it would switch to you to prove. Does that make sense?
Yes, sir.
Okay.
Yes, sir.
And so with the mitigation specialist, then Mr. Cochran can come back to you and say, this is what I think I can do, this is what I think I might be able to prove to the judge, and then you can make a thoughtful decision about whether or not to go forward with a contested hearing or possibly accept the state's offer of the 24.
Yes, sir.
So that's the reason he didn't give you a straight yes or no answer, because there really isn't a straight yes or no until he gets the information and has a chance to evaluate that and then discuss it with you.
Yes, sir. Thank you for explaining that.
You're welcome. You're welcome. All right, we'll see you on 11/20 for a status. If you can advance it sooner, Mr. Cochran, let me know.
I will, Your Honor.
Okay.
I'll get the paperwork from that.
Next is Tracy Rosado, ROSADO.
Is this your stuff?
And this is Rosado?
It is, Judge. This is Tracy Rosado.
You need a minute, Mr. McKinney, or you good?
No, Judge, we're ready.
All right.
She's before the court in 23 CF 457. We discussed this in full yesterday at the jail. She's fully up to speed. To bring the court up to speed as a status today, we're trying to find her placement with APD, and given her designation as a sexual predator, that's causing us some difficulties. So that's expanded our search really to the entire state. I'd like to come back next week on the 23rd for a status. We are filling out applications and expect to get some answers for resources in the Orlando area. That I should know by next week whether or not that is going to be an option or not. I believe once we're able to secure a placement, I would expect that the state may be in a position to move forward in that direction.
All right. And so just want to set it for a placeholder then, you want 11/20, and you can advance it on any one of my dates that I'm here if we need to for the disposition?
I'll have an answer from Orlando by Tuesday next week. So I'd like to come back on the 23rd.
Okay.
Just to keep hands on it, because I know that if we're able to secure a placement, we're going to need to move quickly on that.
Yeah, to keep that bed. Okay, reset for 10/23.
Thank you, Judge.
All right, thank you.
This will be Carol Willoughby.
We did that. Did you get a chance to look this through fully?
Yeah.
Okay.
Sign it there, right? Judge, this is Carol Willoughby. She is here in 24 CF 2445. We have an agreement. May I step back to probation to let them snap a picture of this?
Granted.
I would start at the second.
Judge, the agreement that's been reached is for Ms. Willoughby to admit the violation of probation. We will continue the withhold of adjudication, reinstate to complete the original conditions, and modify to include 60 days in the Okaloosa County Jail with credit for time served. There will be a $100 BOP fee, a $150 cost of defense. For probation's benefit, she does have a hold for Walton County for the DUI that is the basis of this violation. Even though she was in jail here, they have her in FTA status there. So she will be picked up by Walton County and brought back through first appearance over there. So as soon as she gets out, she knows to check in through probation in Fort Walton. Okay, may I approach?
Granted.
No score sheet objections.
Bless you.
Need a furrowed brow.
Please approach. Okay.
I didn't even look at it. So we're trying to fix it quick. And
We'll
There's-
provide a new one, Judge.
Okay.
the court doesn't care for whiteout, so. No, I'm gonna do a clean one. I'll print a clean one. I was teasing.
I'm not so concerned about that. I'd rather do it once and do it over, but I think it's already got a file stamp and a signature on it.
Yeah, I was like, I'm
I'm not sure that's going to work.
Probably slide it in there.
I don't mind if they're marked up because, I don't want Madam Clerk to have to worry about holding it or flagging it or whatever, but at the same time,
Some of the paperwork.
probably a little too much work
Yeah, a
around.
little.
All right, and that's not about you, it's about the paperwork.
Yeah, that's what you
Okay,
just told me.
Okay, all right, I just want to be sure. Raise your right hand for me, please. Would you raise your right hand, please? Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
Yes,
Okay, you put your hand down. You heard what Mr. McKinney said, and you signed the written plea form?
yes, sir.
You understand by this plea arrangement that you're admitting the violation?
Yes, sir.
And that says to me, I violated just the way the affidavit report says I did.
Yes, sir.
Do you understand by doing this, you're waiving your right to a hearing where the state would have to prove your violation?
Yes, sir.
In this case, adjudication will continue to be withheld. You're going to be reinstated to your original conditions, modified to include the 60 days county jail credit for time served, plus the fees and costs that are announced. Is that your agreement?
Yes, sir.
Mr. McKinney answered all your questions.
Yes, sir.
Satisfied with what he's done for you?
Yes, sir.
Court will find the plea to be freely and voluntarily entered into. Thank you.
Thank you.
I'm going to let Walton County know that you're coming again, just to make sure.
Okay, thank you.
Thank you. Kyle Robeson, Roberso.
Morning, Judge.
Good morning.
Judge, I believe there's just an error on docket. First name Jacob, last name Roberson. A little mix-up on the middle name, Your Honor. And this is in
Okay.
case 25 CF 503 for violation of probation this morning.
And are you appointed in this case?
I should be, because I am appointed on his two other cases, Judge.
All right, PD is appointed, Madam Clerk.
Excellent, thank you.
And should his other cases be on with us today?
They are not, but I do have the case numbers, if I may announce them.
All right, please do.
Judge, 25 CF 1638 And then there's 25 CF 1435.
Okay. And do you know when those are set, Mr. Koch?
Yes, Judge, they are set on that 11-12 in custody docket.
Okay, are you going to enter a denial on this and then set it for those dates?
Yes, Your Honor.
Okay. Any objections stated?
No objection, Your Honor.
All right, and so to be clear, the proper name is Jacob Schuyler Robertson, not Schuyler Jacob.
That is correct.
Okay. So Madam Clerk, if you'd make that adjustment, please. All right, very good, thank you.
And Your Honor, speaking with the state yesterday, we are trying to resolve all these cases. If we can, I can move you up before that next date. If not, we're all set on that 11-12 date. Okay, Jacob? Thank you. Thank you, Judge.
You're welcome.
Next will be Timothy Smith.
Are you on Timothy Smith too?
Unrepresented.
All right. Good morning, Mr. Smith. You're here today without a lawyer. Do you want a lawyer to help you?
Yes, sir.
You able to afford a lawyer on your own?
No, sir.
Okay, I'll appoint the public defender to represent you. You'll be given a copy of an application you need to fill out and turn in. I won't ask you to do it today, but you can do it at the jail and turn it in at the jail, okay? If you provide him a copy of the application, please. Mr. Koch will be representing you in the case. It's a VOP, Mr. Koch.
Yes, Your Honor. If I just may, Mr. Snell, if I may just see this offer.
You had a chance to chat with your client, Mr. Koch?
Yes, just brief. Judge, speaking with Mr. Snell, there's an 1129 offer to revoke in term, but at this time we'll enter denial so I can speak privately with my client at the jail.
All right, denial is entered. We'll set it without subpoenas.
Yes, Judge.
1120.
1120 is our next court date, but I'll talk to you privately at the jail.
Yes, sir.
Yes, sir.
All right, Your Honor. We have Mr. Nicholas Atkinson, Your Honor. He has two case numbers, 2018 CF 172 and 2018 CF 1034. Your Honor, we entered denial today and asked to set this for the next court date.
With or without subpoenas?
Without, Your Honor.
All right, 1120, no subs. Thank you.
Just go ahead in your case. I haven't talked to the state or anything yet. Once I know, Jim will come talk to you. All right. All right, bye.
John Hurley, B-U-R-L-E-I-G-H will be next, but we're showing out of custody for that.
Yeah, he was released. Bond order went through yesterday.
Next will be Stephen Hardwick, H-A-R-D-W-I-C-K.
That's you, isn't it?
Is it Hardwick?
How are you? My name is Jason McCain. I'm going to be your attorney for the violation of probation. Is that what this is? What type of hearing is this?
I don't have a violation.
Judge, may I have one moment?
Yes.
Judge, in quick review of the record, looks like this is being returned back from Florida State Hospital. In review of the confidential mental health report, it looks like the court could find him competent and place him back on the docket.
All right, state accept the report.
Yes, Your Honor.
All right. The court will, any issues from the defense point of view?
No, Your Honor.
All right, the state and the defense have accepted the report. The court finds the defendant able to proceed, and we'll set this for the 11/12 docket.
And Judge, given the nature of the case and it looks like the age of the case, we're going to ask the court for the ability to add this onto an earlier docket if we reach an early resolution.
Absolutely. If you have a resolution, just let me know, and we'll put it on any time.
Yes, sir. I'm going to come meet with you after, sir.
You have a report?
I do. I'll get you a card, okay? I'll come meet with you, and we'll try to get this thing sorted. Thank you.
Can you figure out why that's
It's over 16. Sign and then date.
Your Honor, today we have Mr. Danny Nose in case number 24 CF 2674. Mr. Nose is going to be entering a plea today. Today, Your Honor, my client's going to admit the violation. In exchange, the state has agreed to terminate and revoke probation, 6 months Okaloosa County Jail with credit for time served, cost of prosecution, cost of defense, and court cost. If I may approach, I have a signed plea agreement.
Granted.
And there's the score sheets there also.
Score sheet objections?
No objection to the score sheet.
Raise your right hand, please. Do you swear affirm to testify truthfully in this matter under penalties of perjury?
Yes, sir.
Okay, and you can put your hand down. You heard what Mr. Cochran said. Oops, got an extra page here, Mr. Cochran.
Yes, sir, I am.
And you signed the written plea form.
Yes, sir.
Do you understand you're pleading no contest to, that you're admitting the violation in this case?
Yes, sir.
And that says to me that you did violate your probation like the affidavit report says you did.
Yes, sir.
Do you understand you're waiving your right to a hearing where the state would have to prove your violation?
Yes, sir.
In this case, your probation will be revoked and terminated. You'll be sentenced to 6 months county jail, credit for time served, with $100 cost of prosecution, $150 state-provided legal assistance. How much time will you need to get all your fees and costs paid after you get out? You think a year's enough, or you need a little more?
I should be able to do it within a year. I mean, yeah, about a year.
All right, as long as you're making payments, if you need more time, let me know, and I'll give you more time to pay, okay?
Yes, sir, thank you, Your Honor.
And Mr. Cochran answered all your questions about the plea and how it affects you?
Yes, sir.
Satisfied what he's done for you?
Yes, sir.
Find the plea to be freely and voluntarily entered into and accept the plea. Thank you.
Thank you, Your Honor.
Next will be Terry Price Jr.
Judge, this is Mr. Terry Price Jr. in 24 CF 1926, 25 CF 254. If I may have just a brief moment, Your Honor. Judge, Mr. Price will be entering a change of plea this morning. First want to address the 24 CF 1926 case will be a lesser included petty theft, first degree misdemeanor, Florida statute 812.014, subsection 2, subsection E echo 1. And for that case, it'll be adjudication of guilt and credit for time served. In the 25 CF 254, driver license revoked habitual felony, this will be the withhold of adjudication, 3 years of standard probation with the $40 per month cost supervision. Court costs for both cases will be $785, $250 defense costs, restitution in the amount of $180.15, and that's to Family Dollar. And I did provide the address on this plea form. 24 hours community service, no contact with Jonathan Higgins, no return to the Family Dollar located at 913 North Beale Parkway in Fort Walton Beach, Florida. I do have a signed plea form, score sheet. I did have to correct the court cost, Your Honor, with my pen, and I had myself and Mr. Price initial by it. If I may approach with the plea form and score sheet.
Granted. Bless you.
After the judge announces the plea, probation will talk to you with a check in. You'll be released today. Your mom is present, and I got her up to speed.
Thank you. Thank you.
All right, raise your right hand for me, please. Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
Yes, sir.
All right, you can put your hand down. You heard what Mr. Koch said on your behalf and signed the written plea form?
Yes, sir.
How old are you?
30.
And how much education do you have?
High school diploma.
All right, you able to read and understand the plea form?
Yes, sir.
Did you do that before you signed it?
Yes, sir.
And is what you've read in the plea form what Mr. Koch just announced to me?
Yes, sir.
Do you understand by this plea arrangement that you're pleading no contest to these charges?
Yes, sir.
And by pleading no contest, I understand you to say you believe the state has the evidence necessary to prove your guilt and you're not going to contest that.
Yes, sir.
Do you understand by doing this, you're waiving your right to a trial while the state would have to prove your guilt?
Yes, sir.
In this case, adjudication will be withheld. You'll be on probation for 3 years with some fees, cost, and restitution, and also no contact with the stated person, and you can't go back to the Family Dollar.
Yes, sir.
Has Mr. Koch answered all your questions about the plea and how it affects you?
I'm sorry, Judge. Judge, just my client just wants us to say he also has some college in addition to that diploma. Thank you.
Thank you very much.
Yes, sir.
Has Mr. Koch answered all your questions?
Yes, sir.
You're satisfied with what he's done for you?
Yes, sir.
Court will find the plea to be freely and voluntarily entered into, and will accept the plea. If you'd step over this way for your fingerprints, please.
Yes, sir. Thank you.
Best of luck. I'm sorry.
Willie Simmons, Jr.
You're welcome. Judges, Mr. Simmons in two cases, 2020 CF 2302, 21 CF 1506, Your Honor, for violation of probation. We'll be entering a denial this morning, Your Honor. I am requesting a court date after the 11/12, just to get the court up to speed. The allegation is a new law, and that's a misdemeanor in front of Judge Mason, and that's in 25 MM 2617. That's the basis of the violation. Ms. Yeski is his public defender in that case. and I believe this is going to be set for trial. They may even demand speedy trial on this one, Judge, so I'm asking if we can get a court date after 11/12 to have them address that case in Judge Mason's courtroom.
All right, so that would be 11/20. You think that's reasonable, right, Madam Clerk?
Right now, that 25 MM case is set for 11/12, but I need to speak with Ms. Yeski about potentially doing a demand for speedy trial to get that geared up and ready to go.
And what case numbers do you have on this one?
I have 2020 CF 2302, 2021 CF 1506.
Okay. For some reason, only so 1506 and 2302.
That's what I have on mine, Judge, yes.
And say again the misdemeanor case number?
Certainly, it's 25 MM 2617, and that's with Judge Mason. And that case is currently set for 11/12, but Ms. Yeski may file a demand and speed that up.
All right, we'll reset this for 11/20, and that's without subs, right?
Correct, Judge.
Can we?
Thank you, Judge.
Can we set that with subpoenas on that day? That's after the court date for the misdemeanor, right?
Judge, I'd push back on that. The allegations are stalking through, cyber stalking through text messages, and we haven't received any text. I just want to make sure that discovery comes through. I don't believe I'll be...
The problem is that if we don't do that, then at that date...
Okay, well,
then we're at-
let's do it this way. That's a month away, essentially, a little more than a month away. Y'all put your heads together over the next 7 days and talk about this discovery. Because if it's a substantial amount of discovery that's got to come from devices and then get into a format to be admitted, the defense has to have that right to be prepared for a VOP hearing. If you can't get it to them, then I can't very well hold their feet to the fire to do a VOP hearing on that date. So right now, I'll set it without subs. If you can put your heads together in the next 7 days and arrange to get all that discovery, then yes, I'll leave it on I'll move it to an evidentiary hearing. But we've got to have, I guess what I'm thinking is I don't want to set it for an evidentiary hearing on our precious time in the afternoon, only to get there and say we haven't been able to get that discovery taken care of and produced so that everybody can proceed forward. Does that make sense? So it'll be no subs unless after the 7 days you contact and say we've got that discovery squared away and it's been produced so that the defense can be ready, and then we'll move it to the afternoon.
Okay.
Yes,
All right?
Judge.
Yeah. Well, let me finish my notes on that.
Yes. Judge, Mr. Roberto...
Hold on just a second.
Yes.
Okay, I'm sorry.
Yes, Judge. This is Mr. Roberto Soto Pantoja, 25 CF 1692. We are set for a bond hearing this morning, Your Honor.
All right. Go ahead.
If I may, if you can please swear my client, Judge, for some brief testimony.
Raise your right hand, please. Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
I swear, Your Honor.
All right.
Excellent. Thank you, Your Honor. Can you please state your full name for the record?
Roberto Jose Soto Pantoja.
Excellent. I first want to address your current bond. You have a battery, domestic violence set at $1,500 cash for professional, and tampering with a witness at $1,500 cash for professional, totaling $3,000 cash for professional. Why can't you post this bond to get out?
All my banking information, Your Honor, is in my phone. I don't have access to my phone right now. It's in a residence. I don't have, I'm between a hard place and a rock. I don't have any funds available right now to post that bond.
Okay. And when you said the residence, you're stating your phone's at the residence where this incident allegedly took place?
Correct.
And you understand there's a current contact, no contact with that case?
Correct.
Okay. Now, if you do get released, where will you be staying knowing that there's no contact, no return to that residence?
At a friend's house.
And where do they live?
Freeport.
Okay. Are you a veteran?
Yes, sir.
Honorable discharge?
Yes, sir.
Okay. I know we talk privately, we don't have to talk about our private discussions, but it looks like you're aware that potentially we have a vet court offer?
Yes, sir.
Okay. And that the next vet court is on October 23rd?
Correct.
And if you are released, you understand that it's your, not responsibility, but you need to get there for that court date?
Absolutely, sir.
Okay. And you understand that while you're out, if you do get released, to get your discharge paperwork?
Yes, sir.
You will be able to do that?
Yes, DD 214. I got a copy of that form.
Okay. And, Judge, I have no further questions for my client.
All right, State.
I don't have any follow-up questions for the defendant.
All right, and what is the, well, if you'd approach, please. All right, and we'll hold this defendant until we have an opportunity to get more information.
Okay, so we'll see you soon. Yep. Judge, this is Mr. Brandon Stone, 25 CF 996. If I may have a brief moment to talk to Mr. Schnell, Judge. Thank you, Judge. We have reached an agreement. If you recall, Judge, the original charge was amended so my client could enter the 90-day program. Of course, he's back now, and the state wants to amend it back to that original charge. We do have an agreed-upon resolution of this case, but the state does need to amend the charge back. If we can hold on to my client to this afternoon to enter that plea, give the state time to amend those charges.
Okay, well, so that'll fix that. Okay. Madam Clerk was just indicating there was some discrepancy between the stated charge and the section, but that should fix it.
Okay.
All right, so we want him back at 2:30?
Yes, sir.
That'll be enough time? All right, so we'll bring him back at 2:30 so that we can take the plea at 2:30, okay?
Thank you, Judge.
All right,
See you
thank
this
you.
afternoon.
Colby Knight, K-N-I-G-H-T. Over here. Good, may we have a moment? Mr. Knight is here in 20 CF 2772. We've reached an agreement on the violation of probation. He's going to admit the violation of probation. He'll be adjudicated guilty. He was previously adjudicated. The sentence that has been crafted here is 1129 Okaloosa County Jail with credit for all time served. That is concurrent coterminous with Escambia County 24 CF 2399. That case has already been served in the Department of Corrections. Revoke and terminate supervision, $100 VOP fee, $150 cost of defense. And the intention with this agreement, because he came back on the violation after he had served his DOC sentence, is that he has served that amount of time, and then his probation would be revoked and terminated since all of the restitution and everything was paid by family.
So we had this problem, I guess, last week or 2 weeks ago, right, Mr. Gomez, on that other case where we had confusion over how we worded that for DOC.
Well, that's why I wrote it as an OCJ, 1129 OCJ, if we stipulate that the sentence has been served,
okay,
rather than a Department of Corrections sentence,
okay.
I think we're fine.
Okay, all right, good. All right.
And it is a negotiated downward departure based on the payment of all the restitution and all the costs. I think there's an outstanding amount of 4 cents that we can take care of. Is that correct, probation? The outstanding 4 cents?
Yeah, it's just for court costs, so it'll just, it's just court costs.
Okay.
So
May I approach?
there's nothing we can do about
Granted.
that.
Sure.
It just closes.
All right. So, to be clear, this is a credit for time served sentence.
Correct.
Okay. Raise your right hand. You swear affirm to testify truthfully in this matter under penalties of perjury.
Yes, sir.
All right, and you put your hand down. You heard what Mr. McKinney said, and you signed the written plea form.
Yes, sir.
You understand that you're admitting the violation.
Yes, sir.
And that says to me I violated just the way the affidavit report says it did.
Yes, sir.
And you understand by doing this, you're waiving your right to a hearing where the state would have to prove your violation.
Yes, sir.
In this case, you'll be adjudicated guilty, your probation be revoked and terminated. The sentence is a guideline sentence to the Okaloosa County Jail for 1129 with the understanding that it's concurrent and coterminous with the 24 CF 2399 case in Escambia County, and that the state and the defense stipulate that you have all the time served. And so that is, in essence, a sentence of time served. Is that your understanding?
And Judge, with the court's pronouncement, it is a negotiated downward departure.
It is a negotiated downward departure. Is that your agreement?
Yes, sir.
And Mr. McKinney answered all your questions about the plea and how it affects you?
Yes, sir.
Satisfied what he's done for you?
Yes, sir.
Court finds the plea to be freely and voluntarily entered into and accepts the plea.
Thank you.
Okay. Thank you.
Yes, sir.
Thank you.
Next will be Jeffrey Scott.
Judge, this is Mr. Jeffrey Scott, Jr., 22 CF 2980.
All right.
Judge, we are scheduled here. I filed a motion to dismiss for lack of jurisdiction.
All right. Give me a chance to get there.
Yes, Your Honor.
Thomas, who is this again? I'm sorry.
Jeffrey Scott. It's with David.
I just want to let you know, since Jason was running distraction tactics.
This is your motion, right?
Yes.
All right. Stay.
So it's my understanding there was a affidavit filed shortly before the expiration date, or the time, the end of his jurisdiction for his case, and then the warrant for his arrest was issued after the expiration date. And I believe that the warrant had to be signed before that date. That's my understanding of the rules. So that I would agree with his motion.
All right. State concedes the motion. The motion is granted, and the VOP is dismissed for lack of jurisdiction, and therefore the probation is terminated by running of time.
Yes, Your Honor.
Correct, if you address this.
Thank you.
All right, submit a proper order so it's it's in the court minutes.
Will do.
Okay.
Thank you, Judge.
Thank you.
Next will be Rico Williams.
Williams.
Yeah, this is Mr. Rico Williams before the court. He's here in, I believe, a total of 4 violations of probation, and we're working on a misdemeanor as well. They were trying to
misdemeanor as well?
Yes, Judge, I don't have that case number off the top of my head, but there is a pending misdemeanor that our intention is to wrap up at the same time as these violations of probation. I need to meet one more time with Mr. Snell to review the score sheet for Mr. Williams. So if we could pass this over to next week, we should be in a position to have a resolution.
All right, so put it on for no subs on the 23rd?
Yes, sir.
All right, done. Thank you, Mr. Williams.
Thank you, Judge.
This will be Michael Wilsey, W-I-L-L-S-E-Y.
Judge, this is Michael Wilsey before the court. He's here in two case numbers, 23 CF 1041 and 23 CF 2312. The court had signed an order for an evaluation in this matter. In reaching out to the evaluator, I believe that's going to happen tomorrow. So I wanted to stress to Mr. Wilsey that it's important to actually go forward with that evaluation. And then I would ask the court for the first available date in November to get a report from the evaluator.
All right. All right, Mr. Wilsey, they'll be there to talk to you tomorrow, so it's important that you participate, okay?
All right.
All right, thank you, and we'll set it for 11:20.
Next we have Simone Thompson.
Thompson?
Judge, and I believe we've reached an agreement with the state. I have not had a chance to write a written plea agreement for Ms. Thompson. If that's something the court wishes for me to do, we would need to call her back.
I'd prefer that, yes.
Yes, sir.
If we can hold Ms. Thompson so Mr. McKinney, after his cases are finished, can write up a plea agreement.
Chris, are you guys done with out of custody people?
No.
Yeah, they're not.
Yeah, we haven't done out of custody yet. Oh, Are we done with in custody?
First, 9 o'clock.
Jump. You ready? This one saved this one.
This one looks like it's clean inside.
Mr. Burley. It's not here. Mr. Ryan Martin. Who's present and approaching, Your Honor. One moment, Your Honor.
Need another minute, Mr. Cochran?
No, Your Honor, we're
Okay. All
ready
right,
to
go
address. Your Honor, my client is scheduled to do his DUI course the first week of November. It's the last thing we're waiting on. We asked to set this for that November 20 court date.
All right. Any objections, State?
No objection, Your Honor. Once he completes that requirement, we've notified the defense that he will dismiss the VOP and revoke and terminate, or just terminate probation.
Okay. All right, so reset for 11:20. Keep up the good work.
Thank you. Thanks, bud. No problem.
Judge, I have a matter that's on the 1:30 docket, who's president of the courtroom, may I pull that down?
Yes.
Madam Clerk, that is going to be Natalie West on the arraignment docket.
25 CF 1892.
Correct. I believe the state may have an announcement in this case.
This time, the state would announce a no pros. There will be a hard copy filed today on that. The alleged victim in the case declines to prosecute. So.
All right, case is no price. Thank you. Good day.
Thank you. Thanks.
Mr. Aaron Martinez. Your Honor, we'd like to set this for the next court date with subpoenas.
All right. With subpoenas, right?
Yes, Your Honor.
All right, so 11:20 at 2:30. All right. Thank you. Good day.
Call my office and we'll set up, we need to talk. Okay. All right? Yes, sir. Go ahead.
Call my office and set up an appointment.
All right.
Ms. McDowell, Your Honor, I asked her to come in this afternoon to, Mr. McLemore, he has two cases, 25 CF 0379 and 25 CF 562. Your Honor, he is in federal custody at this time.
Didn't believe me.
I don't expect we'll see him for a little bit.
All right. I'm sorry. You made me lose my train there. Who is this again?
This is Mr. Gervais McLemore. It's number
Okay.
24 and 25 on my docket. Or no,
Okay, so that's 25 CF 562 and 25 CF 379, is that right?
yes, Your Honor.
And he's in another institution?
Yes, Your Honor.
So what do we wish to do with the status of this case?
Can we put it on for the next miscellaneous date? I've actually been developing a pretty good relationship with the federal attorneys, and if I can figure out what they're going to do on this case, we may be able to run something concurrent, but I can at least give us a status on.
The next is next week. Longer than that.
No, oh yeah, no, I'm at like December. I'm not going to be here next week, so.
First date in December, Madam Clerk. 12/11, and that's for status, right?
Yes, Your Honor.
Okay. And if something changes, let us all know, and we'll reset the nature of it. You know, if there's something, you can get a disposition concurrently.
Absolutely, Judge.
Okay.
Ms. Mara Mearns?
It's not here.
Mearns?
Continue to distribute narcotics to the citizens of our county. We know of at least 2 buys or sales that she did. There was a search warrant executed at her home where methamphetamine was found in her room, in her possession. And here we are. She demonstrated with her actions that she had really had no intentions of ever not dealing drugs with the court. She indicated to her attorney through to me that this was a mistake and she is not a drug trafficker and everything. And her actions since she entered the plea show differently, Your Honor. And so I got a transcription of the plea from the 15th, and it's really clear that the court asked Ms. Sloan, did she understand that this is a plea to the court if you get new arrests? And she answered through her attorney, absolutely, and went through the whole array of what she could get sentenced to up to the 37 years, and she acknowledged that she understood and she wanted to enter the plea. I would assume that it's, at this point, she's pled to the information as filed, so I wouldn't be able to increase the charge as far as count 1 is concerned. Well, it'd be count 2 on the information because we're dismissing count 1. I would like to provide the court with a document, and I don't know if Mr. Koch, you have an objection to that? No, this is your specific case.
Yes, thank you.
You sure if I approach that?
Absolutely.
May I approach, Your Honor?
Yes, sir.
Judge, may I also approach with Mr. Snell?
Granted.
Yes, Your Honor, thank you. I first want to address that even throughout this case, Ms. Sloan had no failures to appear. She always abided by showing up. I know that there is that current case out there, the 25 CF 1969. Of course, these are still allegations. I know she was arrested, but we are set for arraignment on that date. Mr. Snell did provide the current score sheet as we pled out on 9/15, reflecting 32.025 months. Of course, we entered the minimum mandatory on 9/15 for 3 years, which would be just slightly above the guidelines. If I have one brief moment, Judge. Thank you, Judge. Just to finish up, we're asking for the 3-year minimum mandatory that we pled to. My client does have a severe drug problem, clearly, by this behavior. She wants to move forward for the 3 years. Hopefully can get some treatment and, of course, stay here in Okaloosa to address these new allegations, Your Honor.
All right. Mr. Snell?
Yes, sir.
Any objection to the State's Exhibit A they tendered at the bench during our conference?
No objection, Judge.
State's Exhibit A is admitted.
Your Honor, based on the new circumstances that arose after the plea, it is the state's position that if we were to talk about it in a contract, since she's violated the agreement was for her to enter a plea on the 15th and that she would obey the laws of the land and she would report here today for sentencing to the agreed upon sentence. However, in light of the information that she was actively continued to sell drugs out of her home, even after entering a plea to go to prison for having trafficking amounts, it was 108 grams, Your Honor, in her purse of methamphetamine. She's a significant and an active drug dealer in our county, and based on the totality of her prior criminal history, her current actions, and her total disregard for and respect for being caught and being under a sentence and still continue to deal drugs to the citizens here in our county, the state's going to ask for 15 years Department of Corrections, Your Honor.
Mr. Cox.
Here's my response would be the same of, we're requesting this court 3 years, and my client indicates she has a drug problem and wants mercy from this court for the 3 years, seek treatment in the Department of Corrections, Your Honor.
so as pled, it's 14 to 28, correct?
That's correct.
That's correct, Judge.
And I'm confused between the two separate score sheets. The proper score sheet is the one that shows a total of 70.7 points, correct?
That's correct.
Okay.
That is correct, Judge.
Anything else?
Judge, just quickly that when we originally pled out the case on the 15th of September, count one did not have a factual basis. I know you made that clear on the record. No matter what, that would have been no pros. I just wanted to add that.
All right.
Thank you.
All right. See, the reason I do what I do when we defer sentencing and then we have that conversation is to make clear what someone's obligations are. And this arrest was 11 days after her sentencing. I don't have the warrant, so I don't see the background information. But probable cause was found for the issuance of a warrant, and probable cause was found at the first appearance. Now, for whatever reason, I don't, on the first appearance paperwork, I don't see that this case, the case we're here for today, nor the misdemeanor case were brought to the attention of the first appearance judge, who I feel confident if they were made aware would have revoked her pretrial release at that time and would have put everyone in a fairly different position than we are today. However, it's clear that the defendant has not complied with the provisions regarding the open plea to the court and the agreed upon sentence. I see no reason that the court is bound by that agreement at this point in time. And the court believes that imposing that sentence would be not consistent with the interest of justice based upon the plea we went through, the approach we took, and the goals we were trying to achieve. And therefore, given the circumstances presented, the court will sentence the defendant to 15 years in state prison and credit for time served and the proper assessment of fines, fees, and costs. No supervision to follow. Count two is a minimum mandatory.
Judge, will she remain in custody here at Okaloosa to address?
Well, she's got a revocation of her bond in the other case.
Yes, Judge.
And and she's got a first appearance or got her arraignment in the other case. So that would be something. And what I'm going to do is revoke her bond in the the 25-1969 case, her bond is revoked. That way she'll be held here to answer for her charges.
Yes, Your Honor.
Isn't there an imposition of a mandatory fine in that or not? $50,000 fine is imposed together with the surcharge for the clerk.
Yes, Judge.
And you can take this one back.
Yeah, right.
Say again? Charles needs to be fingerprinted.
Okay.
Good morning, Mr. Noakes.
Good morning, Judge. I got caught up in Walton County.
No, sir, I understood. You let us know, so as I've told you before, as long as you let us know, I'm fine. I know that everybody has to run the roads back and forth.
Yes, sir. All right. Still stressful. Still stressful. I hate to have anybody waiting on me. Judge, we've got Mr. Purnell here, 24 CF 2414. Judge, initially, this case was a level, I guess, a first-degree felony level 10, and he was referred to have a pretrial detention hearing. The court found that there was grounds to grant the state's request, and so he's been held without bond now since his arrest on the initial case, which was October 15th of 24. Judge, the state then, on August 14th, filed an amended information alleging manslaughter, which is a second-degree felony level 7. So we're asking the court to consider granting him a reasonable bond. I will tell the court that I don't believe that he has any priors. However, there is a current possession of controlled substance that he is being represented by Larissa Dudley that's still pending. I don't know if it's with your court or some other court, but I know that I'm aware of that. But we're still asking the court, I believe he would be entitled to a bond to be set on this amended charge.
When was the amended information filed?
The amended information, Judge, was
Or it's
filed.
8/14, yes.
8/14, yes, sir.
Ms. Ferndon.
Your Honor, the state had filed a motion for pretrial detention on October 16th of 2024. That was prior to any information having been filed in this case. At that time, the state cited just the offense of manslaughter as being what the anticipated charge was. There was a full pretrial detention hearing on October 24th, 24, in which Investigator Swain testified. Evidence was presented to the court. Mr. Purnell was held pursuant to the pretrial detention statute, as manslaughter is an enumerated dangerous crime. The initial information in this case was filed on October 28th of 2024, where Mr. Purnell was charged with aggravated manslaughter of a child, due to the fact that that statute requires, in order for an individual to be convicted, that Mr. Quyon was a caretaker. And in this situation, he is alleged to have been the dealer of the fentanyl that resulted in the death of the juvenile. The charge was amended on August 14th, 2025 to manslaughter. It is the state's position that pursuant to 907-041, paren 5, paren A, paren 10, manslaughter is classified as a dangerous crime. There have been no factual changes in the circumstances surrounding the crime, only a change in the charged information that will be proceeding against Mr. Purnell. He does have another case pending before this court in 2024-164, which is one count of possession of cocaine with intent to sell or deliver for 10 grams of cocaine that was found next to him in the driver's side pocket door. There were also 2 bags of marijuana. A search warrant was executed in that case, and inside the defendant's bedroom, it is alleged that 349 grams of marijuana were found. It's the state's position that pretrial detention is still the appropriate resolution for this case, that there has not been a material change in circumstances since the time that hearing was held, and we are asking the court to continue to detain Mr. Purnell.
So, as you can see, I'm just reading the the statutes and how they overlap in the nature of the two separate charges. The reason I'm doing that is, and once again, so Mr. Purnell, you'll know, the lawyers know this, I put my thoughts on the record because I think people are entitled to know how I come to my decision, and if there's an appeal, then I'm happy for the appellate court to understand my thought process, because if I'm wrong, I should be corrected. And that's for the benefit of the state and for the benefit of you and your attorney. As I understand the pretrial detention statute, it's still relatively new. There's not a lot of law out there that talks about how courts are supposed to look at this. But in reading the cases that I've read and the education I've taken, in evaluating a change in the charge and whether the court should look at a change in a previously entered pretrial detention order based upon the change in the charge, the court should consider how different the charge is from the charge which originally generated the pretrial detention order. Okay? So you can clearly see, I'll just make an absurd example, you know, it was originally, you know, premeditated murder and now it's littering. Well, clearly, you know, that's a major change in the charge that would, clearly, the court should reconsider the detention. However, if the circumstances are similar, the proof is similar, and the charge is similar, then the court's position in reviewing all of that is that the court should not reconsider the pretrial detention motion absent some significant change in circumstances. So what we have here is we've changed from a first-degree felony to a second-degree felony. It is the same charge, it's manslaughter, and the difference is it's under subparagraph 1 as opposed to subparagraph 3. Subparagraph 3 activates the provisions for child abuse or neglect, essentially, and subparagraph 1 does not have that provision. So that's the only difference. The material facts alleged are the same. And so the court does not believe that under those circumstances the change is sufficient for the court to reconsider the pretrial detention, and therefore the court declines to exercise its jurisdiction to modify the pretrial detention order. The motion is denied.
Yes, sir.
Yes, it should be rescheduled for the 12th.
Right. Instead of 11:10, it's 11:12.
Okay.
Thank you, Your Honor. That's all I have.
Yes, ma'am. Thank you, Ms. Herndon. Good day. Mr. Nopes, I show you, I think, one other today. Is that right, this morning? Well, it's
Yes,
still
sir.
morning?
Well, yeah, I've got one this afternoon, but Dana Melson is on the docket, Judge.
Yeah, and I saw that, and it wasn't clear to me. I think she is in a different institution, correct?
She is, Judge.
And we were just here for a status, right?
Just for a status.
That's correct, Your Honor.
All right, so,
I don't believe we've received any report from Florida State Hospital, to my knowledge.
have you, Mr. Nopes? I have not.
I have not, Judge.
It's about time, though, isn't it?
Yeah.
It should be. I would assume that we should be getting a report sometime in the next
April
2
17th
weeks.
is when she was held to be incompetent.
All right, so we want to, let's put this off into our 12/11 date for status, just to keep up with it. I don't want that report to come in tomorrow, and let's not have a court date, right, set to review her status, okay? All right, Madam Clerk? Okay. Now, I've got you this afternoon, Mr. Nopes, right?
Yes, sir. I have another matter that's not on the docket I'd ask to approach on.
Sure, absolutely. All right. Mr. Koch.
Judge, I have one more on the docket with Ms. Barickman. This is Mr. Mark, last name Snyder, 25 CF 130.
Snyder. Mark Snyder, yes.
Judge, this is a status for,
I think Mr. Snyder is in a different institution.
that's correct. He's with the
And have you had the benefit of his recent communications?
The mail, yes. I also have the current, I don't know if the court has been provided a copy of the status on his incompetent to proceed.
No, I haven't.
If I may approach, Judge.
Sure.
You got it? Okay. I knew that's one.
I wonder if that has been filed. Say again. There it is, okay. Thank you. Yes, no, I did see that. Thank you, Mr. Koch.
Yes, Judge.
And so you know, on the communications that I've received, I indicated that we'll be doing I think we forwarded them to you and did a nullity for you to take appropriate action as you think is necessary.
Yes, Judge.
And the state had the benefit of those as well?
We have, Your Honor.
Okay. All right. And so at this point, considering we got that report and there's continued inability, I'm not going to reset a date at this time. We'll wait for the department to do something.
Yes, Judge.
Okay. All right. Right, he remains not competent to proceed, and no further date until we hear communication from the Department of Children and Families. All right, are we ready now to get back to Roberto Soto Pantoja?
Defense is ready, Judge.
Your Honor, if I may call someone's in the courtroom who's going to be a plea.
All right, yes.
Miss Tanika Williams, the Queens.
She's on the 9 o'clock. She's it's Mac Williams. She's both got no attorney and Mr. Cochran.
I'm AJ.
You're welcome.
Guideline sentence, right? Guideline sentence, right?
Yeah, it's kind of, she doesn't score.
Yes, Your Honor. My client's here on two cases today. First is 25 CF 0103. On that case, we'll be entering a plea today. On the other case, 24 CF 2263.
Hold on. I've got 25-1451 and 25-103. You've got 24, what is it?
I think it's the old. Yeah, that's an old case, sorry. The other 25 case number. 0103, we're entering a plea on. The other one, we'd enter a plea of not guilty and ask for it to be set for the November 10 court date.
Oh, so just not guilty pleas and November 10.
Yes, Your Honor.
Is she also on the arraignment docket?
Yes. Actually, I think it's still put for this morning.
She's already entered the plea, it's not guilty plea on 25 CF 103.
Okay, yeah, it's on there twice.
25 CF 1453, she failed to appear and it was set today for a change in plea.
That one we would like to set for November 10. That one we will be challenging. The 25 CF 0103 will be entering a plea into today.
So I think the clerk said she's already entered a not guilty plea on 103, correct? And so on the 1451, what are we doing with that?
That one would ask to set for November 10.
Okay, which is the ordinary pretrial day.
Yes, Your Honor.
Okay.
And then 25-0103, I have the plea form and score sheet here.
Oh, so you're pleading on 103?
Yes, Your Honor.
Not guilty on 1451?
Yes, Your Honor.
Okay.
Sorry there.
That's okay. All right, let's have your plea on 103.
All right, 103, Your Honor. In exchange for a plea of no contest, the state has agreed to adjudicate 1-year probation, which is coterminous with 24 CF 2263. Restitutions in the amount of $450 to Destin Ulta Beauty in Destin, $350 to Sephora, and $700 to Buckle. That's joint and severable with co-defendant Akila Mitchell. $100 cost prosecution, $150 public defender fee, and any court cost. And given that she is paying a significant amount of restitution, I'd ask the cost of revision be waived.
State?
No objection to that, Your Honor, but that is our agreement.
If I may approach, Your Honor.
Granted. Raise your right hand, please. You swear or affirm, testify truthfully in this matter under penalties of perjury.
Yes, sir.
All right. You heard what Mr. Cochran said, and you signed the written plea form?
Yes, sir.
How old are you?
43.
How much education do you have?
I graduated.
All right. You able to read and understand the plea form?
Yes, sir.
Did you do that before you signed it?
Yes, sir.
And is what you read in the plea form what Mr. Cochran just announced to me?
Yes, sir.
You understand you're pleading no contest to the announced charges?
Yes, sir.
And that says to me, you believe the state could prove your guilt by evidence to a jury, and you're not going to contest that?
No, sir.
And you understand by doing this, you're waiving your right to a trial by jury where the state would have to prove your guilt.
Yes, sir.
And you'll be adjudicated guilty. You'll have the probation announced, and you'll have the restitution, and you'll have court costs in the amount of, Madam Clerk?
$550 and $150
All right. All right. And Mr. Cochran answered all your questions about the plea and how it affects you?
Yes, sir.
And you're satisfied with how he's represented you?
Yes, sir.
All right, the court will find the plea to be freely and voluntarily entered into and will accept the plea.
Thank you, Your Honor.
Your Honor, I just wanted to make
Yes,
sure.
hold on, just a second. Okay, so, one small detail. 25 CF 1451 is not in this division.
It was supposed to be transferred the last time it came up.
I think we like orally transferred it or something, didn't we?
Yeah.
Well, that's as good as the paper it's written on.
What division?
Can I orally
It's in question.
transfer it, Madam Clerk?
Can I orally dismiss it?
You want to dismiss 1451?
That's correct, Your Honor.
Does the state announce the null pros in 1451?
That's correct, Your Honor.
The state announces null pros in 1451. All right. So who else we got this morning?
Judge, there's an individual in the courtroom with last name Muldoon. I didn't see him on the docket.
Muldoon.
Judge, this is not my case, but it looks like Sean, Muldoon. It's 23 CF 2472.
Look at that. He love you, didn't he?
And he has a notice for a violation of probation for this morning.
Yeah, it's a notice to appear for today.
Yes, sir. What is that?
I looked, I didn't even see you on the dockets. They may not even know about it to have anything for you. But I didn't want you sitting back there all day.
Thank you.
Just hang out here.
Okay.
The judge looks at it.
Okay.
All right, so is the state prepared?
Not really, Your Honor.
Because I guess my only concern is the defendant lives in Pensacola and traveled here today for this. The notice to appear was signed by the court on 9/4.
I can prepare myself in a minute or two, Judge.
The recommendation is, it's an issue regarding compliance with the UAs, and the recommendation is to mandate a modification for a drug patch. Cost to be borne by the defendant. Now, I don't think we have a drug patch program here, but I think they do in Pensacola.
I would be good with maintaining the withhold, modifying to add the requirements of complying with the drug.
Do you understand what probation is asking?
No, sir, I do not. What
Okay.
is the drug?
Probation is, probation has a choice to ask for a warrant. They have a choice to ask for a notice to appear. And they didn't ask for a warrant, meaning they didn't send the sheriff out to arrest you. They asked you to come to court today to answer for what they believe is a violation.
Yes, sir.
But not have you arrested. Their request is that because of the problems that you're having complying with the drug testing, is that instead of doing the traditional drug testing, that you have a drug patch, which will be applied, I think it's every 6 weeks, and that you be responsible for the cost of that, and that will assist in having them supervise you effectively on the no drugs provision.
Okay.
And that would be, so what would happen is, if you agree to that, we would modify your probation to make that provision and dismiss the violation, is what they're asking for. Now, you're here without a lawyer, you're entitled to have a lawyer if you want a lawyer to help you. And so I could continue the case and appoint a lawyer to do that. Or if you feel comfortable that you can agree to that condition, then you can do that without the help of a lawyer, but that's up to you.
I'm just not aware of what a drug patch is. What is that? Like, is it an actual patch, or is it?
Yeah, I mean, I've seen them. It looks like, kind of like one of those, you ever have one of those scrapes where they put one of those clear patches on you, where a clear bandage, you know, where you can see right through? It really looks really
like a
horrible.
nicotine patch
You know?
or something?
Yeah, but the drug patch is kind of like that, but it has a particular piece of technology in the fabric that then when they remove the patch, they're able to, using a particular, if you're taking drugs, then a bit of the metabolites of the drugs transpire, in other words, move through your skin and are absorbed by the patch, and then they can use a particular testing protocol on the patch to determine if you've been using drugs, as opposed to the traditional UA that they use for, that's the way the technology works.
I'm okay.
And there's a cost. I don't know what the cost is. I can't tell you that. Now, once again, you can accept that, or if you want to have a lawyer and you can't afford one, the court will appoint the public defender to represent you if that's your desire.
I mean, if the cost isn't extreme, I'm okay with that.
Once again, I don't know what it is. That's something probation might be. We don't have it in Okaloosa County yet, but.
I didn't know that in Escambia County had a drug patch. This is the first I've heard of it.
Well, that's their recommendation in their VOP, is for the drug patch. So it's my understanding they recently implemented that through the folks in the organization in Santa Rosa County.
So they're probably outsourcing it to the scram. Whoever does the scram, I think they might do the drug patch.
Correct.
I don't know how much that costs, but it only lasts for 1 week, so that means you'd have to do a drug patch, as far as I know, every single week.
I think, I understood. I don't know. I don't know is the answer. So if you want a chance to go and find that out, we can reset this for November the 20th, and you can go talk to your probation officer and get that information. And if you have an agreement to do that, then you can write a letter and say, I agree to that modification, and then we can take your plea on that modification.
Okay.
Or your probation officer can send an order over modifying your probation to make those provisions.
Okay.
Is that what you'd like to do?
Yes, sir.
And if you're not agreeable to that, then you want a lawyer, then let me know that as well, and I'll appoint the public defender to represent you, okay?
Yes,
All right.
sir.
So, and I'm not going to give you another order, I'm just going to tell you that you need to be here on 11/20, okay?
11/20.
Right, the 20th of November at 9 o'clock.
Yes, sir.
Okay, all right, thank you very much.
Roberto Soto,
All right, state and defense had the benefit of the pretrial paperwork for this?
Defense did, yes, Judge.
And then the terms and conditions are no contact, not be within 500 feet. The evaluation, recommended treatment, medications as prescribed, comply with all recommended treatment, access appointments for medication management, and be on MPPTS. And considering the nature of the charges, if the court were to consider the bond modification, I would add a provision for GPS to the mental health pretrial services conditions because of the nature of the allegations involved. State?
Yes, sir. So I have had the benefit of talking with the alleged victim, Mr. Soto's wife, and she's here present today. She's very concerned for him. They have a long marriage. They have children together. Mr. Soto is I believe that Mr. Koch indicated, is a service veteran. He's been deployed multiple times and served our country honorably. He has some things that have negatively impacted his life from that service, and some other things. They've had a horrific family tragedy that really added on to that. And Mr. Soto has turned to things to medicate that have not been very helpful, and it's really caused some struggles with their family life. From everything I can tell, this is a perfect case for our Veterans Treatment Court, Your Honor. It would be perfect. The state has extended an offer to the defense of a diversion contract to complete the Veterans Court, would give him treatment. It would allow him to, get back to getting healthy again. And the issue, the $1,500, I think, is an appropriate bond. The state's not saying that that's not appropriate. However, the best situation would be it'd be easy if I could get the veterans, the VA outreach employee to come and see him at the jail. I could get Miss Kathy White to have the evaluation, and it would be the quickest thing. I could get him on the Veterans Court docket. It'd be ideal. The concern the state has with the address that he's indicating that he's going to go to is part of the problem, where he is self-medicated. That's one of the reasons. That's a big downfall. He has criminal charges in Walton County. It's correlated and connected to that residence and the people that live there. All of this lines up with the issues that he has based from his service, Your Honor, and it's the state's concern if he were to be released to go back to that setting, he's put himself right back into harm's way, because he's currently has a POCS charge, a POP, and a grand theft auto charge out of Walton County, and those people there, that's not the right. If he's going to get well, that's not the right place for him to be, from everything that I can tell from what I've gathered, my research here and talking with the folks involved in the investigation and whatnot, Your Honor. So I would ask the court not to modify the bond. I think $1,500 is appropriate per charge. The victim in the case is not against the defendant. She wants to help him in every way that she can.
All right, so, let me see if I can restate as best I can.
Okay.
You believe an alternative sentencing is the best outcome from the state's point of view, and that would be a treatment court.
Yes, sir, because he
and
needs
you're concerned that if he gets out, that would be handing him a shovel to dig a deeper hole.
That's correct, and he might need to go straight into inpatient treatment. We need to get that evaluation. So,
Mr. Koch.
Yes, Your Honor. I first want to address, my client has no pending controlled substance charges. We're here, of course, for domestic violence and tampering with a witness. That Walton County case, speaking with my client, of course, that's not my case. It was a rental car dispute to return, so it's nothing to do with controlled substance. I'm not minimizing any of our cases, but I want to make that clear. In reference to the $1,500, normally that's an acceptable amount, but as my client stated under oath, he does not have access to his banking information, leaving him with no funds to get out. My client's been in custody for 61 days. He is a veteran, honorable discharge. We've spoken about vet court, and my client wants to go to vet court. He knows the vet court's going to be October 23rd. My client has a valid license. He will be attending that. I will also be present. I believe those pretrial conditions, especially that GPS, can alleviate any concern. Also, just to notate, my client has no prior felonies, no previous failure to appears. I'm requesting 5,000 signature bond on each count, totaling 10,000 signature, with all those pretrial release conditions. My client will be living at a separate residence at Freeport. He has a valid license. He will maintain contact with me, and we will be at vet court together on 10/23, possibly entering that diversion ultimate program, Your Honor.
All right. I'm going to defer to the vet court judge to decide whether to grant that bond motion. That way we'll know he'll be there on vet court on 23 and see the vet court judge. And if the vet court judge believes that that's an appropriate thing, then we'll do that after the evaluation's done. If not, and you're back here, then I'll reconsider. Okay?
So just for clarification, Judge, for my client, he will remain in custody until that 10/23 court date.
Correct, and if the vet court judge feels it's appropriate and he enters vet court and they agree to modify, then okay. And if he doesn't enter vet court and you're back here, then we'll readdress it.
Yes, Your Honor.
Okay?
I will see you 10/23 vet court. Thank you. Yes, sir. Thank you.
You want the 1:30 inmates, Your Honor?
I need to take a break.
Okay.
I have one more that's in the courtroom. It's going to be a plea.
All right.
If I may, Your Honor.
Please.
Ms. Kelly Midget? All right, you had actually entered a capias on this, Your Honor?
All right, withdraw the capias.
We have Ms. Kelly Midget, Your Honor, 22 CF 2562. Today, my client is going to enter a plea of no contest. In exchange for entering the plea, the state has agreed to withhold adjudication, 2 years of probation, which will auto early term upon payment of all funds due. And we would ask to convert the remaining community service hours that she had from her pretrial into court fees.
All right.
If I may approach, I have signed plea form and swear sheet.
Granted. Raise your right hand, please. Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
Yes, sir.
Okay, and you can put your hand down. You heard what Mr. Cochran said and you signed the written plea form?
Yes, sir.
How old are you?
40,
How much education do you have?
some college.
All right. You able to read and understand the plea form?
Yes, sir.
Did you do that before you signed it?
I did.
And is what you read what Mr. Cochran just announced to me?
Yes, sir.
Do you understand you're pleading no contest to the announced charges?
Yes, sir.
And that says to me you believe the state could prove your guilt and you're not going to contest that.
Yes, sir.
Do you understand by doing this you're waiving your right to a trial by jury where the state would have to prove your guilt?
Yes, sir.
Adjudication will be withheld. You're going to be in 2 years of probation. Early termination upon payment of all funds due. Okay, payment of all funds due. What does that mean? Because I was looking, there's significant restitution.
Yeah, that's the restitution and the community service hours.
All right.
So my husband and I,
It's, the restitution is the main thing.
The restitution of Lowe's, I can't remember, $2,800 or something like that.
Yes, Your Honor, she's paid significant amount of court costs and everything else already.
I think what we should say for the particularity would be 1,200 due to Lowe's.
Okay.
That way it's
So specifically
stated.
1,200 due to Lowe's.
So it's not joint and several, you're dividing
No,
it.
just her.
So restitution of 1,200, is that the state's agreement?
Yes, Your Honor. To Lowe's.
1,200 to who?
To Lowe's.
Lowe's.
Lowe's in Fort Walton.
Yes.
Oh, no, it's Destin. It's Destin.
Destin, I'm sorry. Destin.
Destin?
Yes.
Because he didn't do his part.
No, it's actually Fort Walton. The addendum probable cause says 774 Beale Parkway.
It was Destin.
That's what I thought. I just heard her saying Destin, so I
No,
was kind
no,
of-
but it was Destin.
Can we just say what's in the addendum of probable cause?
Well, y'all welcome. Do you see, you got your file, the addendum probable cause says, on September 20, your occupant responded to 774 Beale Parkway, was advised by employees of an incident. Oh, yep, and that's it. So I guess loss prevention is in Beale Parkway and the store was in Destin. Okay.
So it all goes to the same place.
All right, how much are court costs? All right, so payment of the court cost, payment of the restitution, and that's when, and then payment of her community service if she chooses to pay those off.
Yes, Your Honor. Couple of questions. One, since she is paying all these things, she's a single mother, I'd ask that the cost supervision be waived.
Well, she is a single mother. According to this offense happened with her husband.
They're separated, they're divorcing.
Okay, all right. State object to waiving
No
cost
objection,
supervision.
Your Honor. I was told by.
Waive cost supervision. All right.
And then the other, when the PTI was issued, she had previously paid some court costs. Initially, is that, any of that go towards this?
Yeah, if she's paid court costs, she'll get credit for them, right, Madam Clerk?
Yes, I'm showing that she's already paid $615 for the food shop contract, so reimbursement? Any of it too?
No.
No, it would just be the same court cost. Or the state would be okay with just the same.
Right, because I'm showing that she paid, actually 506, right? No, she paid everything. And she paid the prosecution fee, so the only thing that she would owe is the 150 state-provided legal assistance, right, Madam Clerk? Okay. All right, so with all those questions and confusion, have all your questions been answered about the plea and how it affects you?
Yes.
You're saying yes, but your face has a huge question mark. You want me to turn this noise on? You can ask Mr. Cochran any questions you have.
We're good, Your Honor.
Okay, you good? You satisfied with what Mr. Cochran's done for you?
Yes, sir.
Okay. Court will find the plea to be freely and voluntarily entered into. Accept the plea. Chat with probation before you leave. All right. right, so what, we're going to take 15 minutes because, I mean, we all deserve a little break, so 15. 15 minutes. All right, we've got the pretrial detention with Thomas, is that right? Ms. Dudley?
Good afternoon, Your Honor.
Good afternoon, Ms. Dudley.
Your Honor, this is Javaz Thomas in 25 CF 1909.
1909 or 1910?
Oh, I thought it was 1909.
Right.
When we first checked, it was 1910. The second time it had changed to 1909, so I'm not sure if it's.
Is it 09 or 10? Okay. All right, go ahead.
You know, we were originally set for a pretrial detention hearing for today. I don't believe the state's going forward on that.
That's correct.
All right, so we just need to set a bond, is that what we need to do?
Yes, sir.
All right. You prepared to make arguments in that regard?
Yes, sir, I am.
All right.
Your Honor, Mr. Thomas is a lifelong resident of the area. He works at Circle K for the past 9 months. He takes care of his girlfriend, and he has a son. He takes his girlfriend and his son, takes his girlfriend to and from work, son to and from school. He pays all the bill. His mom is present, lives locally. She works as a nurse here. We are asking for no more than $50,000 cash professional bond. Based on my conversation with his mom, that is something she believes she can come up with to make a bond. I've represented Mr. Thomas before. He is not a flight risk. We are asking for a $50,000 or less cash professional bond in this matter.
Based on the nature of the charge and the amount, Your Honor, the state's asking for $150,000 cash or professional. And pretrial services, check-in weekly, no alcohol, no controlled substance, and random urinalysis, and breath testing on both at this time, Your Honor.
So we have the POCS is count 1, correct?
That's what I show you, Your Honor.
And then the trafficking, less than 14 grams, right?
Yes, sir.
Is that correct, Mr.?
I'm sorry, Your Honor.
The charge.
POCS count 1 and less than 14 count 2, correct?
That's correct, yes, sir.
Okay. On the POCS, it'd be 2,500, which is consistent with the circumstances that I've ordinarily assessed. And on the trafficking, less than 14, it'd be 50,000, which is what I normally would assess. Pretrial services, standard reporting conditions, no substances. Now, one thing I will note, though, Ms. Dudley, I'm not sure if you saw in the first appearance, but Judge Ward did revoke his pretrial release in the CT case.
Yes, sir. I'm aware.
All right, somebody going to provide an appropriate order for me?
Yes, sir, we'll do that today.
All right, perfect, thank you.
Thank you, Your Honor. That's all I have, Your Honor, thank you.
Thank you, Ms. Dudley, good day.
Next we have Amber McKay.
Say again?
Amber McKay.
McKay.
Start on the 1:30.
I still have this Thompson from this morning too. Are you ready for this? Yeah, I think you're ready for it.
I have one, I'm sorry, I wasn't expecting. One thing, I'm sorry, Your Honor. McKay. Let me have one moment, Your Honor. If we can, excuse me, recall Miss McKay. This is going to be a plea. I just need time to write it up.
All right, hold Ms. McKay for a plea.
Where's your information?
Thank you. So I just go back, please?
Yeah.
Okay.
JJ, one more day, we'll do it back. This is Small Thompson.
Do you have a chance to read that through?
Yes, sir.
Do you have any questions for me?
6 months, 120 days.
Ms. Thompson is here in 3 case numbers, 21 CF 1491, 1492, and 1493. She's going to admit the violation of probation in each of those case numbers. The agreement with the state is for an adjudication of guilt. She was previously adjudicated. 6 months in the Okaloosa County Jail with credit for time served. Revoke and terminate the probations. There's a total of $300 in VOP fees and a total of $350 cost of defense. May I approach with the plea agreement?
Granted.
No objections to the score sheet, which reflects 30.6 points.
All right. Raise your right hand, please. Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
Yes, sir.
Okay, and you put your hand down. You heard what Mr. McKinney said, and you signed the written plea form?
Yes, sir.
You understand you're admitting the violations?
Yes, sir.
And that says to me, Judge, I violated just the way the affidavit report says I did.
Yes, sir.
And do you understand that by doing this, you're waiving your right to a hearing where the state would have to prove your violation?
Yes, sir.
And you'll be adjudicated guilty. I'd be sentenced to 6 months in the county jail with credit for time served. Your probation will be revoked and terminated, and you'll have the fees and costs that have to be paid. How much time do you think you need to do that after you get released?
I say 30 to 60 days.
Give yourself some time.
Because you got $300 in the cost, $650 of the cost of this proceeding alone, plus whatever you owe on your other stuff. So you sure you can do that in 60 days?
Judge, I think it would be appropriate to ask for a year. You got everything, all the probation, the original court cost, all that stuff. So ask for a year.
A year.
Okay. And as long as you're making payments, if you need more time, I'll give you more time, okay?
Yes, sir.
All right. Mr. McKinney answered all your questions about the plea and how it affects you?
Yes, sir.
All right. You satisfied with what he's done for you?
Yes, sir.
I'll find the plea to be freely and voluntarily entered into, and I'll accept the plea.
Next was Cheryl Oglesby.
Oglesby.
May I have one moment, Your Honor? Your Honor, this is going to resolve this case, and she has a second case. They're both going to resolve today with a plea.
What's the other case number?
I don't have it in front of me. I have it on the plea form.
I just want to be sure Madam Clerk has her minute sheets up to date.
I will give it to her before we bring the plea out.
Okay. All right, so we need to hold Ms. Oglesby so you can write the plea up?
Yes, Your Honor.
Okay. Ms. Oglesby will have a plea written up, and we'll handle her in a little bit, okay?
So I'll have them bring it back to you.
Okay, thank you.
Thank you, Judge.
Yes, ma'am.
Jennifer Sexton.
Judge, we're here in 25 CF 1858. Oh, there, you need a copy.
That's not me.
Sorry, that was the last case. That's your new copy. Judge, at this time, we'll be entering not guilty, waive formal reading, and request this be kept on the November pretrial docket.
All right. So ordered. November 12th, yes, ma'am.
Privately, unfortunately, no offer today. So we'll talk
Next will be Jacqueline Thompson. This way next.
So you're taking it?
Yes, yes.
How are you?
And Mr. Koch, on Ms. Sexton, she has two other active cases, right?
It should be VOPs, if I'm not right.
My name is Jason McKinney. Got it.
And that's the only reason I was slowing down a little bit, because I show she got 24-125 and 24-1029.
I looked at it.
And the judge at first appearance violated her on those two. I don't know if those have hit yet, but Madam Clerk, add those two case numbers to our 11/12 docket. That way we'll have them and nobody will be surprised if they pop up.
Thank you, Judge. And could we be appointed just?
You're appointed on the VOPs as well.
Thank you.
Sorry for that interruption, Mr. McKinney.
This is Jacqueline Thompson before the court. I have two case numbers. Are we looking at the same case numbers, 25 CF 1764 and 1765?
Correct. No information in 1764.
That's correct. Is it,
Do we have arraignments next week?
Yes.
On the 23rd?
We do.
Can we reset 1764 and the 1765 on that 23rd date?
Yes, reset both for 10/23?
Yes, sir. I'd like the opportunity to meet with Ms. Thompson, speak with the state, see if there's a way to resolve it.
So ordered.
Okay, so we're going to come back next Thursday.
What time?
Yes, ma'am.
next will be Kiera Wilson.
Jason McKinney, on behalf of Kiera Wilson, we would acknowledge the receipt of the four count information, waive its formal reading, enter a plea of not guilty, and ask this to remain on the next available pretrial date.
All right, not guilty plea is entered, 11/12.
Judge, if we reach an agreement ahead of time, I'll seek to advance it.
Absolutely, thank you, Mr. McKinney.
Next will be Jermaine Lee.
Jason, while we're here, could you because he was going to be called. All right. All right, here's your information. Your Honor, here with Mr. Jermaine Lee this afternoon. We acknowledge receipt of the information. We enter a plea of not guilty and ask to leave this set for the November 10 or November 12 court date. I believe that's the next court date.
So ordered.
So your next court date is November 10th, okay? All right, buddy.
Thank you now, good day.
I'm working on motions to suppress.
Next will be Julian Lobello.
You got your...
Madam Clerk, do you have information filed on this? Okay. We'll acknowledge receiving the information, Your Honor, enter a plea of not guilty. I'm going to ask to leave this set for the next court date of November 10.
Right, and the defendant also has 22 CF 3007.
What was that number again? I'm sorry.
22 CF 3007. And it should be a VOP. He was violated on that by the first appearance judge.
Okay.
So let's put that on for the same date, Madam Clerk. That way there's no confusion, and you're appointed to represent him in that case.
All right, thank you, Your Honor. I'll make sure my office opens the file.
You got that, Madam Clerk?
Okay, so I represent you on both their cases. I'm Chris Cochran. I'm asking the jail to see. I am looking at a motion to suppress. I just gotta get some more info.
All right. I'll talk to you.
All right, buddy.
Mr. Carlton Mims.
I'll get it, don't worry. If I have one moment, Your Honor.
Yes, sir. No contact with the victim, with the provision that that can be modified if you apply to the court to do so. You've got your fees and costs that will also have to be paid. Has Mr. Cochran answered all your questions with about this plea and how it affects you?
In a way, I just have one question.
Okay.
So,
Well, here, ask Mr. Cochran.
We're good, Your Honor.
All right. And are you satisfied with how Mr. Cochran's represented?
I have. I am.
All right. Court will find the plea to be freely and voluntarily entered into and will accept the plea. Thank you.
Okay, thank you. Thank you, sir.
Christian Lobson.
Yes, Your Honor, we have Mr. Christian Knopfsinger. We acknowledge receipt of the information. Do you have an offer?
No. This is a case, Your Honor, where we received the file and stuff 2 days ago. So we have not had an offer on this case.
Drug treatment center. Okay. So start applying, and I'll come talk to you.
Do you want to reset him for next week to give you a chance as opposed to setting it off to 11/12?
I can try. I personally won't be here, and if I'm not mistaken, I think he's probably going to score a DOC offer, if I'm not mistaken.
We'll let it for November 10.
Okay. And a not guilty plea and set it for 11/12.
11/12, yes.
Start applying for programs.
Next to be William Pearson.
This is mine.
Judge, this is Mr. William Pearson, 25 CF 1781. Yes, Your Honor. Receiving the information, will be entered not guilty, waive formal reading. And Judge, this is a 2013 allegation. I already talked to Mr. Gomez. We'll be chatting more tomorrow, potential statute of limitations issue, but at this time, we request it be kept on the 11/12 docket.
So ordered.
This way, next will be Michael Waters.
Yeah. Michael Rogers, thank you. Judge, it's Mr. Michael Rogers, 25 CF 1687. If I may just have a brief moment. Judge, at this time, will be entered not guilty, waive formal reading, and request this be kept on the 11/12 pretrial docket.
So ordered.
Okay. Thank you, Judge.
So when's it next?
11/12. You're welcome.
Brandon Rothwell.
Thank you. Yes, sir. Judges, Mr. Brandon Roswell, 25 CF 1783. Judge, at this time, we'll be entering a not guilty, waive formal reading, requested be kept on the 11-12 pretrial docket. Mr. Snell is aware my client has been accepted into a Master's Touch program, and we're trying to work out an offer on, hopefully on that 11-12, so you can get treatment.
So ordered. And if that works out sooner, bring it back any day.
Thank you, Judge.
All right.
Excellent. You're welcome.
Nathan Sanchez.
Yes, thank you. Judge, this is Mr. Nathan Sanchez, 25 CF 1857. Judge, receiving the information, we're going to enter a not guilty, all counts, waive formal reading, request is be kept on that 11-12 pretrial docket.
Is there an offer?
Judge, score sheet would reflect guideline sentence of 450 months
And that's the state's offer?
at this time.
All right. All right, we'll set it on 11-12. Thank you.
Next will be Deshaun Shaw.
Okay, I'll hold on. Follow the deputies. Yes, sir. Thank you. Thank you. Judge, Mr. Deshaun Shaw in 25 CF 1879. Yes, Your Honor. We do not have an offer this afternoon. I spoke with the state attorney's office. So we'll be entering a not guilty, waive formal reading, request to be kept on that 11-12 docket, Judge.
So ordered.
We'll talk privately at the jail.
Sharif Thomas will be next.
Excellent, thank you.
Judge, this is Sharik Thomas before the court in 25 CF 1899. I think this case got opened to me yesterday while I was at the jail seeing other people, so I didn't get an opportunity to speak to Mr. Thomas ahead of today. This looks like a case we might be able to resolve. I'd ask just to continue this arraignment until next week if the court will allow.
All right, we'll reset the arraignment on 10-23 unless there's an objection from the state.
No, sir. No objection.
I'm going to come.
Next will be Luis Vasquez, Mayor Cruz.
Good afternoon.
Sorry, español. No inglés.
Okay. We'll bring a translator in a moment.
Un momento, pase, por favor.
Mr. McKinney?
Para Juan.
Micah Walker.
That's one.
Keep number 44 in the seat.
They don't have an offer. Judge, this is Michael Walker before the court in 25 CF 1623.
Can I say something?
We would acknowledge the one-count information, waive its formal reading, and enter a plea of not guilty, and ask for this to remain on the next available pretrial court date. This is a one-count felony petty theft.
Right, associated with and that's where the confusion lies for the court. If you'll see on the first appearance paperwork, he's got the misdemeanor, but it looks like the same. I'm not really sure.
Yes, sir, and I believe that that's already been disposed of in misdemeanor court.
I got time served for it.
Yeah, I know.
So the misdemeanor case is resolved.
That is my understanding.
Does the state have an offer?
Not at this time. It's going to be a DOC offer, Your Honor. So,
All right, so set on 11/12.
Yes, sir.
All right, so ordered.
You got a score sheet now?
I don't have anything yet.
So what I need to say, David?
When I get an offer, I'll come to you.
Pardon, what did you say the court date was?
The 12th of November.
11/12/2025?
Yes, sir.
All right.
Put somebody on that. Let's just start getting people out of the gallery. All right, Mr. Koch, you want to begin calling folks from the gallery?
Yes, Your Honor. Sir, Laura Lee Proctor.
We were appointed in Ms. Proctor's case, and we filed a written plea of not guilty, so she should have been removed from the docket.
You see that, Madam Clerk?
Excellent.
Say again?
And we contacted her at Twitter.com, so.
All right, thank you, Ms. Jacob.
Yes, absolutely.
Keith Shanklin. So Mr. Shanklin, present and approaching in 25 CF 1839. Excellent, thank you. Same copy. Yes, Your Honor. At this time, speaking with Mr. Snell, it's going to be a DOC sentence, so we'll be entering a not guilty. Waive formal reading, request this be kept on that 11:10 pretrial docket at 9 o'clock in the morning.
All right, 11:10.
You are free to go.
Now stay in touch with your lawyer and be back in court on the 10th, okay?
Yes, sir. That's our next court date. The call schedule appointments, we can check before then. Okay. All right? Take that with you. Excellent. Next, Mr. Marcus Simmons. Mr. Simmons is present and approaching in 25 CF 1782. Yes, Your Honor. Thank you. Judge, at this time, we'll be entering a not guilty plea, waive formal reading. Request this be kept on the November 10th at 9 a.m. pretrial docket.
So ordered. Stay in touch with your lawyer. Be back in court on the 10th, okay?
That's our next court date. A call, schedule, so we can talk before then. Take that with you. Yes, sir? Is there Santiago Ramos? Mr. Santiago Ramos, correct, is present and approaching. Please stand right there. Excellent. Thank you. Yes, Your Honor. Will be entered not guilty on all counts, waive formal reading, and request this be kept on that 11:10 pretrial docket, Judge.
Is there an offer?
Yes, Your Honor, be adjudication, 12 months of probation, and clears driver's license or pay all any outstanding fines and get his car registered.
If I just have a brief moment, Judge.
Yes, sir.
Judge, this is going to be the request if we could have a translator to assist.
Okay.
So if you can have a seat, and we'll call you back up. If possible, Judge. All right.
Yes, sir. If you'll have a seat, we'll get a translator to help you with Spanish, okay?
Yep.
If you'll be okay for 1 minute, Charles, I'll run up there.
I believe, is there a Cameron Powley? Present and approaching in 25 CF 1876. See if they have a copy of the...
Powley?
Yes, Judge. And that's 25 CF 1876, first name Cameron.
Good afternoon, Your Honor.
Good afternoon.
Just, Judge, if I see if they have a copy of that information. If
Yes,
I may be
sir.
excused for 1
Yes.
second. Powley with a P. Powley with a P. Oh, thank you, Madam Clerk. Thank you. Excellent. Judge, receiving the information, will be entered a not guilty request to be kept on the 11:10. The nature of these charges is mandatory adjudication of guilt. So I want to hand my client my card with our next court date. But please call and schedule an appointment so we can talk before that.
Of course.
Be back on the 10th, and be sure to get in touch with them so they can chat with you about resolving the case, okay?
Yes, Your Honor.
All right, thank you.
That's all my out of custody, Judge. Thank you.
Mr. McKinney.
Judge, I have Joseph Villarreal. Mr. Villarreal is the president and approaching 25 CF 1874. I believe we would need to set this over to the next arraignment date. We are in discussions with the state.
Reset to 10:23?
Yes, Judge.
State?
No objection, Judge.
All right,
And
so
Mr.
ordered.
McKinney.
And while we are here, I would make a an or a tenant's motion to remove the GPS monitor, which was one of the conditions of his pretrial release after first appearance, and I believe the state would be willing to agree to that.
Given the facts and circumstances in this case, we don't have an objection to remove the GPS as long as all other pretrial conditions remain in place.
All right, so ordered. Now, you'll have to go to pretrial and have them take care of that for you, okay? Okay. All right, and we'll put that in the minutes.
Thank you, Judge.
All right, thank you.
So I'll be back next Thursday at 1:30. Let's keep in contact, and I'll talk to you. If you hang out in the hallway, I'll be there instead.
Ms. Jaquith, how many do you have?
Your Honor, I have someone on 2:30.
Okay.
I left the office way earlier than I thought it was.
Okay.
Judge, may I call Kenesha Williams?
Kenesha Williams, please.
Followed by Roderick Williams. This is Kenesha Williams before the court in 25 CF 1859. We will acknowledge a one-count information, waive its formal reading, enter a plea of not guilty, ask for this to remain on the next pretrial.
Is there an offer in this case?
Yes, sir. It'd be 5 years of probation.
Standard conditions or any specials?
There would be community service, there would be no consumption of intoxicants, and retail theft course, no trespass at Volta. And also maintain employment.
All right.
Judge, I've notated the offer for the record. I'll discuss that with my client, but today we'll maintain the not guilty plea.
Not guilty plea is entered. Be back on the 10th of November. Chat with your lawyer so he has access to you to help you resolve the case, okay?
Okay.
Thank you now.
Thank you.
Schedule an appointment or a phone appointment.
Okay.
Can we, the interpreter, Your Honor, we have two that need Spanish.
All right, let's call our Spanish, please.
Mr. Ramos?
Judge, we are recalling Mr. Santiago, last name Ramos, 25 CF 1886.
Trinidad Suarez, Bennett, certified court interpreter for the record, Your Honor.
Okay, if you'd raise your right hand for me, please. Do you swear to interpret these proceedings truthfully, adding nothing and subtracting nothing?
I do.
All right.
Your Honor, we enter a not guilty plea today. Waive formal reading of the charges. Requesting our next court date be November 10th at 9 a.m. And I am handing my client my card. He's going to call and schedule an appointment. And he knows the next court date's 11/10, November 10th.
While the interpreter's here, do you want to have her recite the state's offer? So your client will be able to think about that pending his appointment with you.
Yes, Judge. Currently, the offer would be adjudication of guilt, 12 months of probation, condition of probation to clear up his driver's license. Think about that offer, but we'll discuss it privately in my
Also,
office.
to get the car registered.
And also to get the car registered as a condition of probation. Think about that offer, but schedule an appointment so we can talk privately. Do you understand? Excellent.
Do you need a moment to talk to your lawyer before you leave now?
Okay, excellent.
I'll turn this noise on so you can get closer, Madam Interpreter.
Thank you, Judge. If we can keep my client on that 11:10 pretrial and he understands to make that appointment so we can discuss his case privately.
Stay in touch with your lawyer and be back in court on the 10th of November. Thank you.
Judge Rivera, Andy, is that Andy?
Yes.
Luis Vasquez, Mayor Quinn.
Your Honor, handed the defendant his information.
Good afternoon.
Buenas tardes.
Good afternoon.
You're here today without a lawyer. Would you
No
like a
tengo.
lawyer to help you?
Sí, por favor.
Yes, please.
Are you able to afford a lawyer on your own?
¿Cómo debo?
What did you say?
Are you able to afford to hire a lawyer on your own?
No.
No.
I'll appoint the public defender to represent you. I'll provide a form that you must fill out and turn in. You can do that from the jail. This will be your lawyer appointed to represent you. I'll give you a brief moment now for you to speak to your lawyer before you proceed further.
Thank you, Judge. We're set for arraignment today in 25 CF 1720. We will acknowledge the receipt of a 14-count information, waive its formal reading, and our plea of not guilty, and ask for this to remain on the next available pretrial date.
Does the state have an offer to resolve this case?
We do, Judge. It would be 15 years in the Department of Corrections, followed by 10 years of sex offender probation with sex offender designation and all of the requirements of that status.
Thank you, Judge.
Thank you very much. And I just got a notice for 25 CF 1721. Do you have that in front? Ramirez. Oscar Ramirez Ortiz.
Your Honor, a no pros on that case was filed 10/7.
Okay. I believe that they just appeared downstairs and are on their, he had a notification to be in Crestview. And they're on their way now. So when they arrive, we'll need you to explain to them what happened. All right, thank you.
Your Honor, I did notice there were a couple of matters that were on the docket still that my office filed a written plea of not guilty, so I figured I'd just address those really quickly.
Jennifer Shane?
Jennifer Shan is one of them, that's 25 CF
Mrs.
1750.
Natale picked that up and took care of that.
She is usually on top of things. I also saw that Mr. Renfro was still on the docket, 25 CF 1838, but the court signed an order transferring that one.
And I show that still assigned to Mr. Koch, but you're on that and it's transferred?
Well, technically we Mr. Harper, but we went ahead and filed a written plea of not guilty and a notice of appearance in Mr. Harper's name as well yesterday, so that should be in there. But yes, our office will be handling that case, but it should be over in the other division. But I did notice it was still on the docket, so just to help keep the record clear, I wanted to address it.
All right, Madam Clerk, do you see that? Okay, squared away. Thank you, Ms.
I can't right now, we need to wait for Ms. Wilson. Thank you, though.
Okay.
I appreciate you.
All right, Jennifer Lample? And I'm sorry if I destroyed your name there, I apologize. How do you pronounce it?
Lample.
Lample. All right, that's Mr. Cochran.
He's out in the hallway talking to somebody.
Okay. We'll get him just a second.
Oh, there it is. Don't you worry.
Sorry about that, Your Honor.
No, it's okay, Mr. Cochran, I know you're working them.
All right, yes, Your Honor. We have Ms. Jennifer Lamp, case number 25 CF 1882. Today, we acknowledge receipt of the information, and we enter a plea of not guilty, and we ask to leave this set for the November 10, or to set it for the November 10 court date.
All right, is there an offer in this case?
No, Your Honor, this is one of the cases that I had emailed you about. We just got it 2 days ago. We've reached out to the victim. We want to make sure that we're aware of what amount of money is owed.
Well, if something comes up, Mr. Cochran explained what's going on with that. It's a documents issue. If something comes up where there's a resolution, Mr. Cochran will reach out to you before that date to make you aware, okay?
Okay.
All right? So right now, stay in touch with him and be back on the 10th.
Okay.
He'll give you instructions otherwise.
All right, thank you.
All right. Brian Lanou.
Silence your cell phones, please.
Have you checked your email in the last 5 seconds?
Yeah.
I just approved.
Okay.
Good afternoon.
All right, Your Honor, we have Mr. Brian Lanou, case number 25 CF 1912. We'll acknowledge receipt of the information.
No, I don't.
No?
No information.
Oh, there was. Hold on. This is another one of those ones, Your Honor, sorry. I printed my copies.
We'll acknowledge receipt, enter a plea of not guilty. Ask to leave this set for the November 10 court date. And also, my office will be filing a motion to withdraw. We do have a conflict. I'll let RCC know that.
Well, Ms. Jaquit's still here, so maybe she can shake hands with Mr. Lanou.
I will give him a card, Your Honor, but I would ask the court not appoint me in court because it's been causing so many issues with the clerk's office and us never getting anything.
Okay. All right.
So I'm aware of it. I'll give him a card. I plan to chat with him before he leaves, Your Honor, but, and I am trying to conflict check really quickly, but,
Okay, I understand because of the documents not catching up, it's becoming a problem for you.
yes, Your Honor.
Okay, so you file your motion, but If that happens, then it's likely that Ms. Jaquith will be your lawyer, so she's going to give you a card so you can reach out, okay? Okay?
Very good.
Jordan Lucari.
She's not taking
Send me an email with that.
Okay. Yes, Your Honor, we have Ms. Jordan Lucari, case number 25 CF 1853. We acknowledge receipt of the information. We enter a plea of not guilty, and we're asked to set this for the November 10 court date. It may resolve before that. The state needs to talk to the victim.
All right. Stay in touch with your lawyer and be back on the 10th of November.
Yes, sir.
Wandra Lucas. Lucas.
I'll look into that, Your Honor.
Just a second. The systems are slow. The court's check notice and the court date and time were properly listed on the bond paperwork. State.
State would request a capias at this time, Your Honor.
Issue capias, no bond. Martinez Ramirez.
Yes, Your Honor, that case was dismissed October 13th.
Madam Clerk, is it possible to get a minute sheet from Mr. Deloria to take downstairs and the GPS monitor on?
Eric Mastromonaco.
Mr. Mastromonaco is here in the courtroom approaching. Your Honor, we acknowledge receipt of the information. We'll enter a plea of not guilty. Ask to set this for the November 10 court date and state we are interested in the PTI.
Is there an offer?
There's a PTI offer that we're going to accept, Your Honor.
Okay, so if you get that done, you can write it up and bring it back any time to get that squared away, right?
Yes, Your
Just set it for that date as control, and if you get it squared away, just bring them back. Let's get things moving, okay?
Yes, Your Honor.
All right. Thank you. Be in touch with your lawyer and be back on the 10th if he otherwise instructs you.
All right, cool. Call my office next week.
All right, Madison McLaughlin.
I should know more about the paperwork.
Got you, no problem.
Good afternoon, Your Honor. We have Ms. Madison McLaughlin, case number 25 CF 1855. We acknowledge receipt of the information. We'll enter a plea of not guilty. Ask to leave this set for the November 10 court date.
All right, is there an offer?
Yes, Your Honor, we offered the same offer as we did for Mr. Mastromonaco. I think I pronounced that. It would be to plead a charge to a PTI, 6 months PTI, court cost, 24 hours of community service work.
All right, stay in touch with your lawyer. Be back on the 10th unless sooner instructed, okay?
Yes, sir.
You call my office, I think. Okay. Ernest Merritt. One moment, Your Honor. Thank you, Your Honor. All right, Your Honor, we have Mr. Ernest Merritt, case number 25 CF 1845. At this time, we'll acknowledge receipt of the information. We'll enter a plea of not guilty. Ask to leave this set for the November 10 court date. Call my office and make an appointment.
All right, and is there an offer?
Yes, Your Honor. Is this Ernest or Tyler? I'm sorry.
Ernest.
Adjudication of guilt, 2 years of probation, substance abuse evaluation, treatment recommended, 24 hours of community service work.
All right. Stay in touch with your lawyer. Be back in court on the 10th unless sooner instructed.
Yes, Your Honor, thank you.
Good day.
Thank you.
Yes, sir. All right, next I have Mr. Tyler Merritt. All right, Your Honor, we have Mr. Tyler Merritt, case number 25 CF 1686. We acknowledge receipt of the information, enter a plea of not guilty, and ask to leave this set for the November 10 court date.
Is there an offer?
Yes, Your Honor. It's an adjudication of guilt, 9 months in the Okaloosa County Jail, or 5 years of probation with 48 hours of community service work.
Okay. Stay in touch with your lawyer. Be back on the 10th, okay?
All right.
Yes, sir. There you go.
Call my office, set an appointment. Oh, here's this yours. Next, we have Dennis Myrick, Your Honor. Case number 25 CF 1885. Your Honor, at this time, we'll acknowledge receipt of the information, waive formal reading, enter a plea of not guilty, and ask to leave this set for the November 10 court date.
Same. Is there an offer?
No, Your Honor, this is one of the ones that we received a little bit later, and I'm going to want to speak with the victim before extending an offer.
All right. Stay in touch with your lawyer. Be back on the 10th unless sooner instructed, okay?
Yes, sir.
All right, thank you now.
Make an appointment, okay?
Okay, 11:10, right? Yep. Thank you, Your Honor.
Thank you now.
I believe that concludes my out of custody.
All right. Carter Spain for Mr. Koch.
Judge, 25 CF 1891. I believe an order was signed today. Ms. Merrifield took over the case, and I saw a waiver on her end on the clerk's site, Judge.
Is that right, Madam Clerk? Spain.
Okay.
All right, Miguel Vargas. So I show Mr. Garrett has filed a written plea of not guilty on Mr. Vargas's case. So that'll remain on for the 10th. Roderick Williams.
Jason McKinney, on behalf of Roderick Williams, 25 CF 1793, will acknowledge the receipt of a one-count information, waive its formal reading, enter plea of not guilty, and ask for this to remain on the next available pretrial.
All right, 11:10, is there an offer?
Trying to get there, Your Honor, I'm sorry.
Did I give you one of my cards already? I'll take this one, you take that one. You just schedule them to talk to you, okay?
Oh, it was, this would be 3 years of probation, Your Honor.
Have you ever been convicted of felony?
Standard conditions, any special?
No,
Okay.
just standard, yes, sir.
All right. Stay in touch with the lawyer, be back on the 10th, and see you then, sir. Good day.
Thank you, Judge.
Christopher Williamson.
Mr. Williamson is present and approaching in 25 CF 1895. We would acknowledge the receipt of two-count information, waive its formal reading, and plea of not guilty. Ask for this to remain on the next available pretrial.
Offer?
It would be 3 years of probation. And court would ask the court to reserve on restitution. I don't believe there is any on this case. And the standard conditions.
Would that be with an adjudication or a withhold?
It would be an adjudication.
Judge will maintain the not guilty plea today.
All right. Stay in touch with the lawyer, be back on the 10th. Twanner Wilson. Wilson, Twana Nicole Wilson.
Apologies, Judge. Are we calling Tawana Wilson?
Yes.
I have sound at the hallway. Jason McKinney for Ms. Wilson, 25 CF 1860.
And the first appearance, excuse me, the arraignment date was in the surety bond as well as the notice provided. So, State?
State would request a capias, Your Honor.
Issue a capias.
Yes, sir.
Your Honor, can we recall Miguel Vargas? Because there's some information about that.
Say again?
Good afternoon, Your Honor.
Good afternoon.
Your Honor, we were actually just retained by Miguel Vargas.
And you filed a written plea of not guilty, and it'll be set on 11/10. I saw that on the progress docket when I called it.
Oh, excellent. Cool. Thank you, Your Honor.
You're welcome. So I think that leaves us with Amber McKay, Cheryl Oglesby.
Those two are going to be pleased. The forms are in the back.
Right, and I think then, although we understand that there's been an old pros on Martinez Ramirez, my understanding is they're on the way, or they're here. And I wanted to announce that with the court interpreter so that they make themselves aware. Martinez Ramirez.
Not here yet, Your Honor.
Okay.
Mr. Cupstead is ready for Brandon Stone when you're ready.
Okay. I'm sorry, Oscar Ramirez Ortiz, not the other way. Oscar Ramirez Ortiz. Stone, you ready for?
Yes, Judge. That was set this morning. We held him over for a plea.
All right.
Mr. Brandon Stone, 25 CF 996.
And no relation, right?
Oh, boy.
Let Judge don't make up. Okay.
She heard that.
Yes.
It literally reads like it's.
All rise. Board is back in session.
I got that yesterday.
Let's go to the police report and be like,
Oh, I did.
you shouldn't have that felon on this one.
It's a white object. Was it a letter?
Please be seated.
Yeah, yeah, but that was, and they recorded a report that was brass in color, not white. True. So.
Was it white?
Ramirez Ortiz show up?
According to the victim. We would.
Yes, the one from Waller, the one that went to Crestview has showed up in the call for the interpreter.
Thank you.
What's up? As soon as they process you out, it'll probably be late tonight, early morning.
That's what I got.
Yeah.
Oh, yeah, I was just making, yeah, I read
Okay.
it and I agreed to it.
All right. I just need you to sign and date. If I have one moment for a signature, Your Honor. Sorry about that, Your Honor. This afternoon, Ms. McKay will be entering a plea in case number 25 CF 1671. In exchange for a plea of no contest, the state has agreed to adjudication, 3 years probation, the substance abuse eval and treatment, 48 hours community service, no contact with the victim, Timothy Slay, cost prosecution, cost of public defender fee. Count 2 would be an adjudicate and credit time served. If I may approach, I have the signed score sheet and signed plea form and the score sheet.
Raise your right hand, please. Raise your right hand, please. Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
Yes, sir.
All right, and you put your hand down. You heard what Mr. Cochran said, and you signed the written plea form.
Yes, sir.
How old are you?
What?
How old are you?
29.
And how much education do you have?
How much?
Education.
High school. I did like 11th grade. And then I
Okay, you
dropped
able
out.
to read and understand the plea form?
Yes, sir. I did.
And did you do that before you signed it?
Yes, sir. I did.
And what you read in the form, is that the same thing that Mr. Cochran just told me?
Yes, sir.
And do you understand by this plea arrangement, you're pleading no contest to the charges?
Yes, sir.
And that tells me you believe the state could prove your guilt by evidence, and you're not going to contest that.
Yes, sir.
Do you understand by doing this, you're waiving your right to a trial by jury where the state would have to prove your
Yes,
guilt?
sir.
You'll be adjudicated guilty, be on 3 years of probation with evaluation and treatment, no contact with the stated person, and your fees and costs. Do you understand that?
Yes, sir.
And those fees and costs are, Madam Clerk? Okay. And Mr. Cochran answered all your questions about the plea and how it affects you?
Yes, sir.
You satisfied with how he's represented you?
Yes, sir.
The court will find the plea to be freely and voluntarily entered into and will accept the plea.
Yes, sir.
Thank you, Your Honor.
Mr. Cochran needs a copy. That's okay.
Cheryl Oglesby.
I know that's what I'm saying.
Are you good with this?
Yeah. I just wanted to ask you one thing.
If I have 1 second, Your Honor.
I just want to be sure they got their copy.
That is Ms. McKay's documents first. And now I have Ms. Cheryl Oglesby, and I forgot to give the clerk the new case number. It's 25 CF 587, and then 25 CF 1856, which is the one that's on the docket, I believe.
Hold on. Who is this?
Cheryl Oglesby, Your Honor?
Okay, I think you just gave me back Miss McKay.
Yeah.
Okay.
Yeah, that was. Yep.
Sorry.
Yeah, you're fine, Your Honor. Yeah, Miss Cheryl Oglesby, case number 25 CF 587, felony battery and resisting without violence. And then 25 CF 1856, it's possession of controlled substance and battery. In exchange for a plea of no contest, the state has agreed, and 25 CF 587 will be 3 years probation, substance abuse eval and treatment, 24 hours community service, a batterer's intervention course, and no contact with the victim. Cost of prosecution, cost of defense. Count 2 would be an adjudication and credit time served. On the 25 CF 1856, count 1 will be an adjudication, 3 years probation, substance abuse eval and treatment, 24 hours community service, batterer's intervention course, and no violent contact with the victim. For the record, the victim is a roommate.
My cousin.
She is allowed to go back there as long as there is no violent contact. Cost of prosecution, cost of defense. Count 2 would be an adjudication and credit time served. Well, you did sign the date this. 10/16/25. Just getting signatures, Your Honor.
Yes, sir.
Do I have a courthouse too?
Yeah. Well, you'll have the whole 3 years to pay it.
And that's all. 16?
Your Honor, if I may approach with the signed score sheet and plea form?
Granted. Raise your right hand, please. Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
Yes, sir.
All right, you put your hand down. You heard what Mr. Cochran said, and you signed the written plea form?
Yes, sir.
How old are you?
60.
How much education do you have?
I graduated from high school.
You able to read and understand the plea form?
Yes, sir.
Did you do that before you signed it?
Yes, sir.
And it's what you read, what Mr. Cochran just announced?
Yes.
Do you understand you're pleading no contest to these charges?
Yes, sir.
And that tells me you believe the state has the evidence necessary to prove your guilt and you're not going to contest it?
I do.
Do you understand by making this plea, you're waiving your right to a trial by jury where the state would have to prove your guilt beyond a reasonable doubt?
Yes, Your Honor.
In this case, these cases, you'll be adjudicated guilty, be sentenced to 3 years of probation with evaluations and recommended treatment, classes that you'll have to take, contact with the victim will be restricted, and you'll have the fees and costs that will have to be paid. Is that what you understood?
Yes, sir, Your Honor.
Madam Clerk, proper fees and costs in the cases?
615 for case number 25 CF 1856 with $100 public defender fee. 867 for case 25 CF 587 with $150 public defender fee.
All right. No. The no violent contact provision, I like to explain that a little bit. No violent contact doesn't just mean no poke in the eye. It means any conduct by you which would cause a reasonable person to believe that actual violence is imminent.
Yes, sir.
So, and I usually point these folks in the green uniform as that reasonable person because they're the person who generally shows up when things are going wrong. And if they show up and believe that your behavior evidences that violence is imminent, right, then that would be a violation of the no violent contact provisions.
Yes, sir.
You understand?
Yes, sir.
And part of the course that you're taking is intended to help you understand how to de-escalate that behavior so I don't see you back here.
Yes, sir.
And that's my goal.
Mine
No
too.
offense to you personally, but I don't want to see you back here. Okay? With that, has Mr. Cochran answered all your questions about the plea and how it
He
affects you?
has.
You're satisfied with what he's done for you?
Yes, I am.
Court will find the plea to be freely and voluntarily entered into and accept the plea.
Thank you, Judge
Thank
Dolan.
you. Good day. Oscar Ramirez Ortiz.
He left, Your Honor. He,
There was a no pros filed 10-7.
All right, did somebody talk to him about that?
I did it, I spoke to him, Your Honor.
Oh, okay, well, I'm sorry, Madam Interpreter. We'll need, do we need her, the interpreter for this afternoon then?
I don't believe so, I believe that was the only case.
Thank you very much. I apologize for calling you in for nothing.
That's all right, Your Honor, anytime. Thank you.
All right, thank you.
Brendan Carson?
Well, hold on, we're going to handle the remote appearance first. Mr. Garrett with Michelle Taylor.
So,
Good afternoon, Your Honor. Daryl Torres on behalf of statewide prosecution.
All right, thank you. All right, I believe we're here because I ordered y'all to talk about a scheduling order and moving things forward. Is that right?
Your Honor, my understanding is this is a motion to modify her bond, although I can certainly address those other issues as well.
Right, because that was one of the issues I had as well.
Yes, Your Honor.
All right.
Your Honor, just to start with the progress of the case so far, we've been working on getting depositions scheduled since mid-September. There's apparently 80 gigabytes of discovery, so I had to mail a thumb drive to the Office of the State Attorney, and they received that email, or received that, and then I received an email on October 7th that had been mailed back to me. I don't quite have it yet. I do anticipate having it in the very near future. It's been like 9 days since they mailed it. We are scheduled currently for a deposition, hypothetically, or depositions on November 4th. However, until I receive discovery, I don't know who to depose specifically. There are, I think, a couple dozen possible witnesses here. And it has been a challenge to get these depositions scheduled because we're dealing with, 3 defense attorneys and the Office of the Statewide Prosecutor. and trying to get that conducted and do it in a timely manner. But at this point, I have not received any discovery whatsoever, although I do understand it's on the way.
All right. Mr. Torres, any help with scheduling there?
Your Honor, I'm not sure why it's taken so long for the terabyte drives to get to Defense Counsel, but I can certainly check because we usually mail it via certified mail. So I'll definitely have someone check into the progress of where it's at. And then regarding the depositions, I believe that those tentative dates are set, but I do understand Defense Counsel's position that they want the discovery prior to the depositions.
And the reason I stirred the pot on this is because last time we were here, I said that there should be a meet and confer, and that I was expecting really a scheduling order to really address these issues so that it would be documented in the court file because of the anticipated amount of time, but I didn't actually see a scheduling order. I really encourage you to do that. I realize that there are other cases, companion cases, but the goal of that was that everybody would be working together so that, we wouldn't be duplicating efforts and continuing the cases unreasonably. So the deadlines the court set for that have passed.
Yes, Your Honor.
And so I want y'all to meet and confer and generate a scheduling order in this case and the companion cases so that everybody's on the same schedule so that we're not duplicating efforts and not having unreasonably delays in this case because of 80 gigabytes of discovery, right? That's where we need to be. So I reiterate that. Now I'll give you one more pass at this, but it needs to be available to the court. And if you can't agree to it, then I'll set a case management conference and we will get all the companion cases in and I'll set the deadlines whether they work for y'all or not. I figured y'all are in a better position to know what your calendar is and set the dates. But if you won't do it, I'll do it for you, and tough luck if it happens to be on somebody's birthday or anniversary.
Yes, Your Honor.
You understand what I'm saying?
I do, Your Honor. And just to be clear, we do have a lengthy email thread with the defense counsel and the Office of the Statewide Prosecutor. So we are all working together.
I understand it, and as I say, the judge gets a snapshot when you show up, all that behind the scenes, and, if I get hit by the Greyhound on the way home today, there's no order in the file which memorializes all of that, right?
Yes, Your Honor.
And the new judge doesn't have any idea what's going on, right? So it needs to be an order which binds everybody, right? And that also means that if another judge makes you do something, you already have a scheduling order that says, no, Judge Stone's already ordered me to do this, right? And so that keeps the cases on path. So that's the reason I want it in the form of an order in this case and all the companion cases, all right? So once again, if that means we've got to schedule everybody at the same time, we'll get them all here at the same time and get it done. I don't want these cases to be unreasonably delayed for everybody's benefit, all right? Now as to the bond motion, which I understand is the issue with the GPS and removing the GPS based upon the nature of her employment and how it creates issues for her in her employment.
Yes, Your Honor, and after speaking with Ms. Taylor, she is both on the GPS and on CC house arrest sanctions at the same time. This has been the case since February. Her concern with the GPS throughout the summer was that it was hot. She was having to wear pants to disguise it. That problem is obviously fading. Her request, our request now is that she be allowed to come off of the CC house arrest sanctions but stay on GPS so that she can be kept track of. In addition, she would be more than willing to check in with pretrial services once or twice per week, but this has been going on since February. She has not had any issues whatsoever. She would still be closely monitored with GPS and, checking with pretrial services or any other conditions, from the court, minus the CC sanctions and house arrest. And I did alert, I'm sorry, I don't know her last name, Ms. Erica, about this yesterday, that this would be the tact of the argument. When I spoke with her about 45 minutes ago, I also told her that we're going to be looking for a slightly different bond modification than what was in the motion.
All right, what's the state's position, Ms. Torres?
Yes, Your Honor. I spoke to Ms. Ottavio, so I'm standing in for her today. Her position is that she would be objecting to a modification in this case. This defendant specifically factually is the defendant who was in the process of delivering a 7-year minimum mandatory amount of trafficking of drugs that were going to an inmate inside of the jail and were being passed through a detention deputy. So Mr. Tavio's position is that there's no change in circumstances that would warrant a modification of her pretrial conditions.
Response.
Your Honor, it just seems like overkill to be both be on GPS and CC sanctions. GPS, they can keep track of her. You know, and it's been this way since February. She's had no violations. She's more than willing to check in with pretrial services. But she would like to be able to do things like, you know, go out to eat with her father, go to the beach, things like that. You know, it's been going on since February. We are still waiting on 80 gigabytes of discovery. Even if this case is expedited, there are, it looks like dozens of potential deponents, you know, and I understand the court wanting this case to get moving, but there's a lot of people involved here. I don't know how much longer it's going to go on for. And so we just respectfully ask the court to modify her bond.
Well, you know, the longer I do it, the more I think about all of the old wags that I learned from the grandparents and the uncles and that, right? And I just think about my grandmother saying, nothing good happens after midnight, right? And so I might be inclined to remove the house arrest sanctions, but at the same time might still impose a curfew requirement notwithstanding a GPS, if that's really what she's looking for. And if she's looking for that to be modified for the terms of her employment, I'm willing to do that. But I'm not willing simply to remove all of those conditions and just leave it to the GPS. I'm just not willing to do that based upon the nature of the charges and the nature of the circumstances surrounding the charges and the purpose of the pretrial release conditions. So under those circumstances, I would be willing to modify the house arrest sanctions to provide for a curfew, and I'd impose a 9 o'clock to 7 a.m. curfew as opposed to the house arrest sanctions. That modification that the court would do.
Yes, Your Honor, thank you.
Okay. All right, so that would be the only modification the court would be willing to do, and so it would be so ordered. Provide a written order so that it's clear, and that way also it will be documented with pretrial services.
Yes, Your Honor, just to repeat the language, modify house arrest sanctions to provide for curfew that is imposed from 9 p.m. to 7 a.m. as opposed to the house arrest sanctions, but she would still be on the CC sanctions? Or that's the same thing?
Well, yeah, because if she needs to leave, you know, if she has to work, then she'd have to coordinate that with pretrial services, right? So it could be modified for her work purposes and so on. So if she's got to change that, so I don't want to just make it a hard 9 to 7, but if she has to modify it, she needs to deal with them. But it's a hard curfew otherwise. Okay?
Understood, Your Honor.
All right?
Thank you, Your Honor.
Thank you.
Thank you, Your
All
Honor.
right, good day.
Have a good day, Your Honor.
Good day.
All right, now back to our queue.
All right, Mr. Kemp and Brendan Carter.
You know, this is Brendan Carson before the court, 22 CF 1148. We have reached an agreement with the state and we intend to enter that negotiated plea today. However, I think there's a few housekeeping matters we need to address briefly. The state filed an amended superseding information to clarify that we would just be pleading to one count. And there was some feedback from the clerk's office, digital services, that there was an issue with that. So we just really wanted to address it and make sure that it was clear that there wasn't information filed prior to an indictment being handed down. This information is going to supersede the indictment, but amend that information to just be the one count of second-degree felony murder with a firearm, as is outlined in that amended information, which is reflecting in the clerk's site.
All right,
So basically, we're just trying to make sure that it's understood by all parties that there are no other counts. The one count that Mr. Carson is pleading to is the one count in that superseding amended information that was filed by Ms. Glisson, and there are no other counts anymore. The state has taken.
When was that filed? So we'll make it yesterday, okay, that way the record's clear.
Yes, sorry, Your
That's
Honor.
okay, so that was filed on 10/15.
Yes, Your Honor.
Okay.
So that reflects the only count the state intends to move forward on, and the state is taking no action on any other counts that may have at any point been filed against Mr. Carson. And we just want to make the record clear so there's no issues moving forward.
Is that correct, Ms. Glisson?
That's correct, Your Honor.
Okay.
And then we did subsequently file yesterday evening a waiver of arraignment, and we waived formal reading of the arraignment.
All right.
We're not going to enter not guilty plea because that seems silly, since we're going to be entering a no contest plea here in just about 3 seconds.
Understood, go ahead.
And Your Honor, as to the one count in 22 CF 1148 of second-degree felony murder with a firearm pursuant to 78204-3D and 775087, sub 2, we are going to be pleading no contest. It'll be an adjudication of guilt. It'll be 25 years in the Department of Corrections, with 25 years being a minimum mandatory sentence. He will receive credit with all time served, and that will backdate all the way to April 26, 2022, moving forward. The reason we did it that way, Judge, is there were a few days that he spent in the Leon County Jail on this charge before he was transported. He does need to pay $515 in court costs and a $150 cost of defense, $479.83 cost of transportation to the Okaloosa County Sheriff's Office. He's not to have contact with any of his co-defendants, forfeit any firearms that were subject to this case, and we are asking the court reserve on restitution, if any is requested, for 90 days to determine the amount and the proper payee, though we do not really anticipate any restitution being requested. And we have no objection to the score sheet. May I approach?
Granted.
And that is the agreement with the state, Your Honor.
All right, so I see the superseding information. And it's docket identification number 201. It clearly specifies that the amended information supersedes the prior indictment that was signed November 18, 22. And Madam Clerk, are you aware of what the issue is from the clerk's point of view? Okay. Because it is interesting that if you review the charges, they show two separate dates of the charges, which I think would be consistent with the original arrest and then the subsequent indictment, but they're not showing the information, they're not showing the charges based upon the amended information. So it's clear that this plea is to the amended information filed 10/15/25 under docket identification number 201, where the state clearly indicates that this is a superseding information which replaces all charges and all counts, prior information and prior indictment, and that this is the only charge remaining outstanding in this case. Is that an accurate statement, State?
Yes, Your Honor.
Okay. All right, raise your right hand. Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
Yes, sir.
You can put your hand down. Now, you've been here during this whole time, this discussion, right? You understand the state's filed an amended information which charges a second-degree felony murder with a firearm.
Yes, sir.
All right? And that is the charge to which your lawyer has indicated you wish to plead today. Is that correct?
Yes, sir.
Now, have you had adequate opportunity to talk to your lawyer about this change in circumstances and the plea that you're going to make?
Yes, sir.
Okay. Now, how old are you?
23.
And how much education do you have?
To 11th grade.
All right. You able to read and understand the plea form?
Yes, sir.
Did you do that before you signed it?
Yes, sir.
Now, according to this plea form, you're pleading no contest to the second-degree felony murder with a firearm charge. Do you understand that?
Yes, sir.
And by doing that, I understand you to say that you believe the state has the evidence necessary to convict you of this charge. Is that what you're telling me?
Yes, sir.
And the nature of that charge is that what the information says is that that you did unlawfully engage in the perpetration or attempt to perpetrate a felony, to wit robbery, and while engaged in the perpetration or attempt to perpetrate said robbery, a human being, to wit Bryson Mitchum and or Brandon James, was killed. And that you did use, carry, or possess a firearm in that set of circumstances. Is that right?
Yes, sir.
And that is what you believe the state has the evidence necessary to prove your guilt to a jury.
Yes, sir.
And you're not going to contest that.
No, sir.
Do you understand by making this plea, you're waiving your right to a trial by jury, where the state would have to present that proof to the jury and convince the jury of your guilt beyond a reasonable doubt?
Yes, sir.
Now, do you understand the sentence that's to be imposed upon you in this case?
Yes, sir.
And what is that sentence?
25 years.
And do you understand that's a minimum mandatory sentence?
Yes, sir.
What does that mean?
Day for day. I gotta do it day for day.
Okay. Now, and you're getting credit for all the time you have, both here and I guess over in Leon County as well. And you must have no contact with any co-defendants. And you must forfeit the firearm. Does anyone claim ownership of the firearm other than you?
No, sir.
Okay.
Well, and it could be that another one of the co-defendants might claim possession of, or ownership of that, Your Honor. But at this point, there's no one outside the defendants in this case who would have any claims to ownership.
Okay, so I should restate, the defendant makes no claim to ownership of the weapon and forfeits any claim.
Yes, Your Honor.
Okay. And you understand that the state may ask for restitution and you may be obliged to pay that.
Yes, sir.
Now, considering the sentence that's imposed upon you, which is 25 years day for day, why would you make the decision to offer this plea to court instead of going to trial? And it's not a trick question. My job is to be sure that you're making a free and voluntary decision. The only way you can make a free and voluntary decision is if you're fully informed of all the consequences of that decision. And it's a serious sentence that you're receiving. So considering you're getting 25 years, why would you do that instead of going ahead and go to trial and forcing the state to prove your guilt to that jury?
I'd rather have a chance of making it back home instead of risking going to trial and lose.
Okay, and if you went to trial and lost, what do you believe the consequences might be for you?
Life.
Okay. So the certainty of the 25 years versus the uncertainty of what the sentence might be if you were found guilty is the reason you're doing this?
Yes, sir.
Okay. And you feel like after putting everything together, it's in your best interest to take this plea that the state's offered in this case?
Yes, sir.
All right. Now, Have you chatted with your lawyer about this?
Yes, sir.
All right, no. Ordinarily, we don't ask clients to tell us what their lawyer said. Has your lawyer told you about the positives of going to trial?
But yes, we have a conversation about it.
All right, she told you about the negatives of going to trial.
Yes, sir.
After talking about all of that, you've made the decision to offer this plea.
Yes, sir.
And this is the only time where I would ask about your lawyer's advice. Is your decision to accept this plea consistent with your lawyer's advice?
Yes, sir.
Okay. And are you satisfied with how you've been represented?
Yes, sir.
All your questions about this plea and its effects on you been answered by Ms. Jaquith?
Yes, sir.
All right. The court will find the plea to be a freely and voluntarily entered into plea and will accept the plea with the adjudication and impose the sentence provided thereupon. Now, given the situation, do we anticipate that the defendant needs to be processed and moved on to DOC, or does he need to remain here for other purposes?
He has no hold or anything. Do you need him to remain? Or you can just bring it back at the meeting?
It can be processed, Your Honor.
Okay. We understand the question, right?
Yes, Your Honor.
Okay. All right, very good. Thank you very much. If you'll step this way for your fingerprints, please.
Okay, let me know if you need anything, okay? Your Honor, that's all I have this afternoon. I believe that's all Ms. Glisson has, if we could both be excused.
Yes, thank you very much. Good day. All right.
Ms. McDowell? Your Honor, this afternoon I have Ms. Heather McDowell, case number 24 CF 2255. Today, this afternoon, Your Honor, my client's going to enter a plea agreement.
All right.
In exchange for a plea of no contest, the state has agreed to adjudication of guilt, 1 year in the county jail, with credit to be given for time that she spent in Escambia County Jail, cost prosecution, cost of defense, and any court cost.
So this is Heather McDowell, is that right?
Yes, Your Honor.
Okay.
And my client would request that rather than being taken in custody here, that her husband be allowed to drive her straight to the jail so they can start processing her, rather than waiting to be taken to the jail from here.
State?
We can't agree to that, Your Honor. We'd allow you to decide that, but we can't agree to that.
I think once she's sentenced, I don't think I have the discretion to do that once she's sentenced. Once she's sentenced, she's in the custody of the Okaloosa County Department of Corrections. I don't think I have the authority to do that.
Okay. Okay. So they're going to take you to custody at the end of this, all right? Yep, you'll get credit. For the record, she will get credit for her Okaloosa time also.
Correct.
All right? You good? Any questions or anything? Okay. All right, if I may approach, Your Honor, I have the signed forms.
Granted. All right, raise your right hand, please. Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
Yes, sir.
All right, you heard what Mr. Cochran said. You signed the written plea form.
Yes, sir.
How old are you?
47,
How much education do you have?
college.
You able to read and understand the plea form?
Yes, sir.
Did you do that before you signed it?
Yes, sir.
All right, does the plea form contain the terms and conditions that Mr. Cochran announced?
Yes, sir.
All right. Do you understand you're pleading no contest to this charge?
Yes, sir.
And that tells me you believe the state could prove your guilt and you're not going to contest it.
Yes, sir.
In this case, you'll be adjudicated guilty, be sentenced to 11 months, 29 days county jail, credit for time served. That includes credit in the Escambia County Jail, your cost of state-provided legal assistance, and proper fees and costs, Madam Clerk. All right, and how much time will you need to get those things paid after you're released?
What was that total amount?
It's going to be $765.
That's for at least a year.
A year.
Okay. And there's no restitution?
No, Your Honor.
Okay. Mr. Cochran answered all your questions about the plea and how it affects you?
Yes, sir.
You satisfied with how he's represented you?
Yes, sir.
Court will find the plea to be freely and voluntarily entered into and will accept the plea. Step this way for your fingerprints, please.
Thank you, Your Honor. And then, Your Honor, we have Ms. Luandra Lucas.
Yes. Withdraw the capias, Madam Clerk.
Yes, Your Honor. We acknowledge receipt of the information in her plea of not guilty and ask to leave this set for the November 10 court date.
Is there an offer?
No, Your Honor, this is one of those ones that we came in a little late. We
All
will
right.
work on it.
Stay in touch with your lawyer and be back on the 10th unless you're given instructions otherwise, okay?
Okay.
All right, thank you now.
Give me my card back.
Yeah.
All right. Mr. Gates with a status. Oh, Miss Rochelle. Lacey Rochelle, please.
She's in the holding cell.
Say again?
She's in the holding cell.
Correction, 75.
May I, Your Honor?
Go ahead, sir.
Your Honor, before the court is Lacey Rochelle. It's 25 CF 1160, set for status for this morning, and I want to advise the court that I just got some discovery, amended discovery on the 9th of October. And so we're going to ask that the court move this to the November 20th miscellaneous docket, because there's also in 22 CF 2748 and 2020, I don't have that case number, 2020, thank you. There's VOPs in those cases, and we're going to attempt to reach a global resolution, which would include the 25 case. So if we could have the November 20th date, it should be resolved on that date. I would tell the court that Ms. Rochelle has been evaluated for the mental health court program. Ms. Thornton says that Ms. Rochelle presents with symptoms consistent with mental health conditions / disorders. And she would be an appropriate candidate for the mental health court program. I also want to advise the court that the state is not in agreement with that, and so we want to proceed to sentencing on November 20th and leave that sentence up to the court's discretion.
All right. We'll leave it on for the 20th.
Thank you, Your Honor.
For sentencing. So we'll put it on at 2:30.
2:30 on the 20th.
Yes, you can approach, yes.
Hi, I'm Wanda Roberts.
So
For
it's
the last
without
20
subs,
years,
but
I've
we'll
been
just do
helping the
the
residents
sentencing on
of
the, on the afternoon at 2:30, right?
Yes, sir.
Okay? All right.
Yeah, I have
All right, so I'm showing, what about Mr. Dayram? We got Mr. Dayram and Mr. Riosti on the sentencings, right?
Your Honor, I actually have a plea
You have a plea?
for Mr. Lewis.
All right, come on then with Mr. Lewis.
And one of my 9 a.m.s showed up, Your Honor.
Okay? Let's take care of Mr. Dayram and then we'll come back to that. And then we'll queue up Mr. Ladson after that.
AJ on that case.
Your Honor, Mr. Lewis is present in 23 CF 2090. He's going to admit his violation of probation. And he is signing the plea agreement. Give me one moment, Your Honor. Your Honor, Mr. Lewis is going to admit the VOP. He'll be adjudicated guilty, assess the VOP fee, revoke and terminate probation. He'll be sentenced to 28.5 months DOC with all credit for time served. May I approach?
Granted.
And there's no objections.
Can I get a picture of that? Please, please, I'm sorry. We still need it for revocations too.
There's no objections to the score sheet, Your Honor.
All right, raise your right hand for me, please. Do you swear or affirm to testify truthfully in this matter under penalties of perjury? I do. All right, you put your hand down. You heard what Mr. Dayram said and you signed the written plea form?
Yes, sir.
How old are you?
32.
How much education do you have?
Like,
high school.
Oh, graduated.
Okay. You able to read and understand the plea form?
Absolutely.
Did you do that before you signed it?
Yes, sir, I did.
And is what you read in the plea form what Mr. Dayram just announced on
Yes,
your
sir.
behalf? All right, do you understand that in this case, this is a VOP and you're admitting the violation?
Yes, sir.
And that says, Judge, I violated just the way the affidavit report says I did.
Yes, sir.
And by doing that, do you understand you're waiving your right to a hearing where the state would have to prove your violation?
Absolutely.
And here, the sentence that you've agreed to is to revoke and terminate your probation and a sentence of 28.5 months Department of Corrections credit for all time served with the fees and costs that were announced.
Yes, sir.
All right. How much time do you need to get all your fees and costs paid after you get released?
90 days.
2 years be good?
Yes, sir.
Okay. And as long as you're making payments, if you need more time, just let me know and I'll give you time.
How much was the fines and fees, Your Honor?
Well, I noticed just looking, you've got outstanding fees and costs from your case, and you've got your new $100 cost of prosecution. So I just want to give you the time you need. You don't have to take the full time, but if you need it, I didn't want you to be crushed, because there's other consequences for you if you don't get it paid. They'll
Yes.
report it and collections and all that other kind of stuff. Mr. Dayram answered all your questions about the plea and how it affects you?
Yes, sir.
You're satisfied with what he's done for you?
Absolutely, 1,000%.
All right. Court will find the plea to be freely and voluntarily entered into, and will accept the plea.
Thank you.
Thank you.
Have a good day, Your Honor.
Thank you. You too. All right. Mr. Ladson with Mr. Riasti. Oh, and
Is anyone here from Mr. Ladson's family? Were you hoping to make a statement? No.
Joseph Riassi for Michael Allen Ladson, who's present before the court in 2022 CF 827, Your Honor. This case is set for sentencing after jury trial for both the possession charge and the attempted murder charge, where he was found guilty by a jury of his peers. This case had been previously set for sentencing, and the PSI had not been adequately completed. It's been, since then, it's been completed and presented to the court. Mr. Ladson has a copy of the PSI, and I've gone over it with him. And we're present to proceed to sentencing.
all right, any additions, deletions, or alterations?
No, Your Honor.
I need to speak. I put in for Nelson here, and I've been trying to get him to quit, to take himself off of my case, and he keeps refusing to do it. So I filed for a Nelson hearing. He's been telling me that he was filing, he told me the day we did the last, when y'all found me guilty, the day y'all found me guilty the second time, on the second charge, he told me that he was gonna come see me the next day and we would file an appeal. He keeps lying to me and telling me that he's got to wait until after I'm sentenced, and all he can sentence is the sentence. He's saying he can't appeal the verdict or whatnot. But also, I want to mention, I know that's one thing, but I'd also like to mention this here. You not remember when we sat in here, me and him were sitting here at this table, and you asked Gomez, well, what are these carrying, or what are we doing when we come in here? The last time to prepare, right before, prior to trial, I guess the possession charge, and he said 3 to 5, and what, 5 to 10, you said? And you remember telling him on a couple of different occasions that there's no min man?
No.
And you don't remember that?
I explicitly did not tell him that.
Well, the trials happen, now we're sentencing. The Nelson is tardy since the trial has happened. As to the appeal, the case really isn't finished until the sentencing is concluded. So the period of time to appeal has not begun until the sentence is imposed.
But isn't his, job isn't it truly done? I mean, once I'm sentenced, he's not really gonna be worried about fooling with me anymore, right?
Well,
but I'd also like to mention, like I said, I haven't been able to get him, you know yourself, you've been trying to get me to fire him, and I just hadn't done it, just trying to go along with the court. It seemed like you've been questioning me, making sure I knew what he was doing. But how is it that they found me? I believe that the questionnaire was wrong, because they asked, it's obvious you can't charge somebody with attempted murder after the police reports clearly states there's 3 or 4 earlier altercations. That's attempted manslaughter. I've been reading up on this. I've been looking. I know how the law works anyway. It's 77 what -4 or whatever the numbers are.
yes, sir. Well, that issue is gone. The jury has found you guilty of those charges. And if you believe those were incorrect, then that would be something for the appeal. But you can't get to the appeal until the sentence is imposed.
So there's no way right now y'all can't just back down to attempted manslaughter, make this something reasonable? I've got children out there, you know, I've got responsibilities out there. I can't just go, I didn't even speak at the trial. Y'all didn't allow the depots to be used. Y'all didn't allow the police report to be used. And these are all things that are part of the police investigation. These aren't like, and then the two, my attorney never did enter the two negative GSR reports that were put in with the two, with the major fingerprints. What happened to them tests?
Yes, sir.
And why can't I get y'all to provide them?
Yes, sir. Those may be issues for some other circumstance, but they're not for today. Today, we're here for sentencing.
I haven't even been to a pre-sentencing investigation. When is that?
Well, you've got the pre-sentencing investigation.
This is all made up stuff. There was one guy come to see me in the jail the other day, but all he asked me was my family's phone numbers, and that's all he asked me, and he left.
Yes, sir. Well, I have the pre-sentence investigation that's been provided, and I guess technically you really didn't, a pre-sentence investigation wasn't required considering your prior history, but I ordered it anyway, and so now we have it, and we're here today for sentencing. So those sounds like all issues that you can take up in an appeal, and you're welcome to do so. And you've heard me say it many times. I have no personal investment in how it goes anyway. If I made a mistake, I'm happy that the people in Tallahassee will correct me.
The last time we was in here before the possession charge, was all that recorded?
Yes, sir. All our proceedings are recorded.
And I have explained, for the record, I explained to Mr. Latson that when I filed my notice of appeal, after the court enters its sentence, I will be asking for multiple for the transcription of multiple court proceedings, not just the jury trials, but the proceeding, a few of the preceding hearings, and then the sentencing hearing and any other hearings in between.
All right. State wish to proceed.
Yes, Your Honor.
Go ahead.
Your Honor, we're here to sentence Mr. Latson on 2 counts, one of them being attempted second-degree murder with a firearm, and the second being a possession of a weapon by a convicted felon. With respect to count 1 of that, the exposure is life. This is a 10-20 life statute. We proceed under the 10-20 life statute. The jury found Mr. Latson guilty of attempted second-degree murder, but then further found the required 3 findings: that he committed it while possessing a firearm, that he actually discharged that firearm, and that he caused great bodily harm to the victim by discharging that firearm. The facts of this incident, I'm not going to harp on them, but just to be brief, this incident was where the defendant had a run-in with the victim and his friends. He was told to leave the premises. About an hour went past, and Mr. Latson chose to go and get a firearm, to load that firearm, bring a loaded firearm into a public building, and discharge that firearm. I think we are extremely lucky that the defendant, or the victim rather, did not die that night. I think we're extremely lucky. Given the individual or the defendant's status as a convicted felon, count 2 is going to carry with it a mandatory minimum sentence of 3 years. Given the potential exposure, I believe the minimum guidelines stores 272.55 months in the Department of Corrections. This is a 25-year mandatory minimum because of count 1. On count 1, there's 25-year mandatory minimum. We do feel as though, even still, the defendant is showing absolutely no remorse for the actions that he took that night. He is still trying to find every little possible way out of facing accountability and responsibility for those actions. Your Honor, because of this, we are respectfully requesting 40 years on count 1, 25 years of it being a mandatory minimum sentence, and then we are requesting 15 years as to count 2 with 3 years of it being a mandatory minimum sentence. Those would run concurrently, Your Honor.
Mr. Riasti.
Your Honor, Mr. Ladson, we never really went into the proceeding, what happened prior to that, because the victim had passed away from unrelated issues. If he was able to take the stand, we would have been able to discuss some of the preceding events that had occurred. In mitigation, the victim, there were a number of arguments prior to Mr. Ladson entering the bar. They occurred at other bars. And during the evening, and at one point he was pushed down on the sidewalk in front of chasers. It's certainly not a justification for entering a bar and discharging a firearm. They shoved him down on the pavement outside. The testimony at trial, he entered the bar and pointed the gun at the victim, and there was inconclusive testimony as to whether he was struck in the face prior to discharging the firearm, or the firearm was discharged at the same time. So it's possible that Mr. Ladson was just going to angrily assault the victim. It certainly is possible that when the gun was discharged, that the victim might have been shot in a more egregious location. The state had argued at sentencing that it was in their final argument at trial that but for him striking Mr. Ladson in the face, he might have been shot more fatally, basically. But it's a possibility that that Mr. Ladson's purpose wasn't necessarily to fire the weapon, and I'd ask the court to consider that in sentencing. 25 years is a significant sentence. The court has entered a sentence today on felony murder where 2 victims were deceased in a plea agreement for 25 years. And I think in this case, where the victim was injured, that a 25-year sentence is just and appropriate. So I ask the court to sentence Mr. Ladson to the 25-year minimum mandatory sentence, and run all the rest of the sentences concurrent with that.
I'd like to say one more thing. I didn't testify myself. I figured just the physical evidence alone would take care of everything itself, just because the physical evidence did not point to me having a gun or firing one. But I didn't even have a gun that night. We got in a fight over the gun because they come over him. When we was fighting, they come over him and tried to shoot me. I was trying to take possession of the gun, and that's why I keep bringing up the fingerprints, because there would have been 7 or 8 different fingerprints on that gun. So, I mean, I understand you saying that you can't make any special accommodations, but is there not a way can I not claim a mistrial or something? There's got to be something I could do, right? I mean, I don't understand how I can just be left here hanging. There's got to be something. And I've got money on the streets. I've got a trust fund. I could get my own attorney. I looked in. I looked in through the jail to get them to get me like a caseworker or whatever, so I could, take care of finances or whatever on the streets, since I don't have anybody to help me out. And they told me they don't offer them services.
Anything further on your sentencing arguments?
Nothing from the state, Your Honor.
Nothing from the defense, Your Honor.
And I understand your argument about, sentences and consistency. What's the difference between this case and the case that I just issued a 25-year sentence on? What's the difference between that case and this case?
I mean, the defendant entered a plea. He
with agreed upon sentence with the state, right?
Yes. It wasn't agreed upon then.
And so I don't accept every plea offer I get, but when there is agreements, generally that's the situation. So that's a...
For the record, Your Honor, my comparison was more in the fact that there were two bodies in that sentence, and there are no bodies in this case. Mr. Meeks was shot and wounded, but he recovered, and that's the gist of my argument with regard to the 25 years as a significant sentence and appropriate for a scenario where there's no one suffered a fatality.
And how is it, Your Honor, like, I've got, my siblings went to school with a fellow named Donnie here a couple of years ago, shot 4 people, and he did 4 years, and admitted to it, and got 4 years, he did 4 years to the day. How is it that y'all are gonna hit me with 25 years? It's not fair. I mean, I don't know the boy's last name, but it's definitely not fair treatment.
Well, the law says that under the circumstances presented, I can't do anything less than the 25. That's what the law provides. I don't have a choice in that matter. So the real question is, should I do more than 25 based upon the evidence that I heard at trial? Mr. Gomez is arguing that based upon the evidence that I heard at trial and after reviewing the sentencing, the pretrial investigation, that 40 years is appropriate. So that's the question. But the 25 is the minimum that I can lawfully give because of the 1020 life statute and based upon the jury's finding. So I don't have the ability to do anything less than that lawfully. And so that's the only question. And the charge carries the potential of a life sentence. And the conviction carries the potential of a life sentence with the 25 minimum mandatory based upon the nature of the charge. And so I've read carefully the pre-sentence investigation and read the circumstances. And I understand that you do have children and you do have family, and your criminal history is in some ways significant, but in other ways episodic. It doesn't show a consistent, persistent pattern behavior that I see in some cases. And then I also read some of the information here, which to the court suggests that there are some mitigating circumstances here, which would induce me not to impose a life sentence, which under ordinary circumstances of the jury's finding would be clearly something that I would do of coming into a public place, a crowded public place, and intentionally shooting someone, as the jury has found. I know you contest that that's the truth, but that's what the jury's found, and that's what I'm bound by. Ordinarily, I would think a life sentence would be the appropriate sentence under those circumstances because of what that does to public confidence and trust in being safe where we are, safe where we want to be. That creates an environment where it just is not acceptable in our society and environment. Looking at the mitigating circumstances described, I can see that there are things that would tell me that that might not be the circumstances. But then also reading it, it seems that there are other circumstances that make me question whether or not that isn't the appropriate, particularly the ongoing substance abuse and erratic behavior that significantly impair your judgment, rendering you unreliable and contributing to emotional and behavioral instability, estrangement from your children and persistent conflict with extended family members, which have deeply strained familial relationships. And the fact that the recent arrest simply underscores a pattern of poor decision-making and an inability to avoid high-risk situations, suggesting the presence of unresolved underlying issues. And so, particularly when the court considers, even if I were to accept all of the facts that you've given me as true, that you were abused at the hands of these people, there was a period of time of almost an hour from everyone's testimony between these interactions and your decision to go home, according to the testimony and the finding of the jury, to go home, procure a firearm, and come back to the bar. Even if it wasn't you procuring a firearm, even if it is, as you said, someone else had a firearm and you grabbed the firearm, you were told to leave. But instead of leaving, you decided to come back and have another confrontation, putting yourself clearly in the zone of danger and putting other people clearly in the zone of danger. That's consistent with the findings. I'm not convinced that if I don't impose a significant sentence on you, that the public is going to be safe and is going to be in a position of being assured that they can be safe in their environments where they go. So under the circumstances presented, I'm going to impose on count 2, I'm going to impose a 15 years state prison on count 2, concurrent with count 1, and 30 years state prison on count 1, 25 of which is minimum mandatory, and on count 2, 3 years of which is minimum mandatory. No supervision to follow. The appropriate fees and costs are, Madam Clerk. So ordered. And that's with adjudication on both counts.
And for the defendant's benefit and for the record, he's been sentenced now, and I intend to file a notice of appeal
Discharge
now.
your obligations
Yes,
to your client, as I know you will, Mr. Yost.
Yes, Your Honor.
So that's,
Right over here.
what is that, 30, 35 total?
30 years.
30.
That's all I have for you, Your Honor.
Good day, sir.
And Your Honor, before Mr. Cochran begins, I don't have anything further if I could be excused.
Yes.
Thank you, Judge.
And Mr. Cochran, Mr. Gomez, if y'all would approach real quickly.
Northwest Florida buy and sell their properties. Give us a call at 850-398-5389.
Hi, I'm Michael Gilbert, defense attorney with Warrior Law. I represent those accused in Santa Rosa, Okaloosa, and Walton County. If you or anyone you know has been accused of a crime, give us a call. We can help.
Back Home Bakery Cafe is 2 blocks from the courthouse on Crestview historic Main Street. We serve
All right,
handmade
so
pastries, espresso,
who's
and
next?
lunch items.
Mr. Nurse. All right, we ready to proceed?
Yes, Your Honor. I have Mrs. Mara Mearns.
Oh, okay. Where is she?
She's present and approaching, Your Honor.
Okay.
This is from this morning's docket, Your Honor. Case number 23 CF 1805.
All right.
Ms. Mearns is almost done with her treatment, which is what was the violation. We're asked to set this to the December plea date, or VOP date, and she should be done with treatment by then.
State.
Oh, sorry, no objection, Your Honor.
So 12/11?
That'll work, Your Honor.
Okay. No, is that right, Madam Clerk? 12/11. Stay in touch with your lawyer, keep him informed about where you are and how's it's going. And so he'll be able to be sure to inform the court appropriately, okay? All right, thank you. All right. The only one I have then outstanding is for Mr. Koch. I showed Terry Price from this morning.
We pled that out, Judge.
Is that a plea?
Yes, Your Honor.
Sorry. We got everybody from this morning, Madam Clerk? Oh, yeah. That was the stipulated bond from yesterday. Burley?
Yeah, sure. I was not able to contact him. I believe probation also attempted to reach out to him. I'm not sure where.
Well, consider he just got out yesterday in the confusion. Any objection to continuing to?
No objection.
You want to put him on next week?
I'm fine with that.
All right, we'll just put him on for 10/23.
Thank you, Your Honor.
All right. All right. Now we're focused on Mr. Nopes and his amended motion. Right?
Judge, as it pertains to the amended motion, I do not attach the original exhibits A, B, and C. So I don't know if you're looking at the amended motion I filed yesterday, but it should have exhibits A, B, and C. Sure has agreed that we can put part of it.
No objection.
Down to the original.
All right. Ready to proceed?
Yes, sir, Your Honor.
State's right, Your Honor.
Go ahead.
State's going to call Officer Ordoki to the stand, Your Honor.
All right. Who's that? Good afternoon. If you raise your right hand, please, Madam Clerk, will you swear to witness? Please be seated. Direct your voice to that microphone in front of you. Speak clearly and distinctly so we can all hear and understand you, and the court reporter who's buried in the back of the courthouse can make a good record, okay? Mr. Gomez, you may inquire.
Thank you, Judge. Good afternoon, officer. Can you please state your name for the record?
Officer Daniel Ordoki.
And where are you employed?
Patrol Officer, Police Department.
What position are you in with the Fort Walton Beach Police Department?
Patrol Officer.
How long have you been with Fort Walton Beach?
Approximately 3 years.
Were you working on the night of February 6, 2024?
I was.
Did you recall an incident that occurred at 8 Gibson Place Northeast?
I do.
Why did you respond there?
I would respond there for a call for service.
And what was that call for service?
Possible murder in progress.
Did dispatch speak with you?
They did.
What did dispatch relay to you?
Dispatch relayed to us that we had a caller on the phone stating they believed that their neighbor was being robbed.
Okay. How does dispatch relay a 911 call information to you?
It can be relayed over the radio or over the CAD MCT.
Okay. And so did you receive a radio dispatch?
Yes.
Did you receive anything on the computer?
Yes.
What information did you receive on the computer?
The computer had notes in regards to what was being relayed to dispatch, reference an individual named Brian calling stating he believes his neighbor is being robbed and that he can hear his neighbor saying, "I don't have anything."
When you first got on scene, what did you do?
When I first got on scene, I approached the area of the residence that was in question. It was apartment 2, and I listened to see if I could hear any sounds of disturbance.
What did you observe at that time?
Upon my first approach, I didn't hear anything. I was listening from a window I believed to be a window of that residence. It ended up being a window of apartment 1, not apartment 2.
And when you first got on scene, you first made that approach, how many officers were on scene?
Nobody.
Had you heard anything, would you have approached the door further?
Yes.
What would you have had to have heard to have caused yourself to approach without backup?
It would have to be viability of life, immediate threat.
After that first approach, what did you do?
I went back to my car, took a position to cover, and waited for backup.
And who arrived for backup?
Officer Houston.
What happened after Officer Houston arrived?
Well, once the backup officer arrived, I reapproached the scene. I listened again from the window. I could hear what I believed as distinct sounds coming from the room. I was still listening at that window, so there was a wall and a steel exterior door between me and apartment 2.
Okay. From the time that you actually got on scene the very first time to the second approach, were you still communicating with dispatch?
Yes.
What was dispatch relaying to you during that time?
I don't recall exactly what was relayed because I had an earpiece in at the time, and so watching the videos I couldn't hear.
To your knowledge, was dispatch still on the phone with the caller?
Yes, there was one update that was given at some point that states that, I don't have the exact verbiage, I have it on my phone, but that he could still hear, the caller, Brian, could still hear the disturbance actively taking place, saying, "Take whatever you want."
And I want to make sure I'm clear, when you approached the door the second time, what did you observe?
I didn't observe anything. I heard what sounded to be a female whimpering and then a male making a loud, distinct sound. I couldn't make the words out through the steel door.
Okay. Did you ever knock on the door?
I did.
Did you knock the first time?
I did not.
What happened when you knocked?
When I knocked, I could hear voices inside saying, open the door," multiple times.
And then what did you do when you heard that?
I attempted to open the door myself.
And what happened?
I immediately got pushed back on the door.
How long did you receive this resistance?
A couple seconds.
Okay. After those couple seconds, what happened?
I ended up getting the door open.
And what did you observe once the door was open?
I observed the defendant directly behind the door, reaching down behind the door.
Okay. What did you observe about the defendant?
He was wearing a, for lack of a better term, a balaclava style mask.
Okay. How many people were in the room?
Total of 4.
And at the time that you entered, how many officers were present on scene?
Initially 2, and a third one showed up.
Once you observed the defendant, what did you do next?
We immediately placed him in mechanical restraints.
Who else was placed in mechanical restraints?
Everybody was placed in handcuffs.
Did you pat anybody down?
I did.
Who did you pat down?
I patted down Pulley, and then the second male individual, I don't recall his name off the top of my head, as I brought him out.
So is it safe to say everybody that was in the room was pat down?
Correct.
Why did you guys pat everybody down?
Due to the allegation of a robbery initially, and then later developed information that one of the individuals stated there was a firearm involved.
After you detained everybody, who did you speak with?
I spoke with Miss Falk first.
Okay. Who else did you speak with?
I spoke with Pulley and the other individual as well.
After you spoke to everybody and you investigated, who was identified as the suspect of the robbery?
Mr. Moore.
During your investigation, what else did you observe about the room? Did you find anything?
Yes, the room was in disarray. There was bags dumped upside down. The bed flipped in pulled away from the wall. I observed a laundry basket behind the door, which contained the firearm that was alleged to be used.
Was there anything else in that laundry basket?
There was a PlayStation and a Michael Jordan sneaker, I believe it was.
Were those directly in the laundry basket, or were they in like another bag?
They were in a bag on top of the laundry basket.
Who did you identify as the victim of this crime?
All 3 of the other individuals inside the room.
Whose PlayStation 5 was inside the bag?
Police.
What about their shoes?
Police.
Did he state how they got there?
He did. He said the defendant ordered him to turn over his property at gunpoint.
When did you develop probable cause to arrest the defendant?
Once I interviewed all three of the other individuals, fully stating that the defendant pointed a gun at him, Falk stating where the gun was located, me observing the gun exactly where it was said to be, which was directly in proximity where the defendant was standing when I made contact.
How long after everybody was detained would you say that you would develop probable cause?
I couldn't give you an exact time. 5-10 minutes.
Were you wearing a body camera at that time?
I was.
Your Honor, may I approach?
Granted.
I'm handing you what is marked as State's Exhibit A. Do you recognize what I just handed you?
I do.
What is that?
This is a copy of my body cam video that I reviewed.
Have you viewed the exact video that's on that disc?
I have.
Is that your signature in the bottom left-hand corner of that envelope?
It is.
Does the video that you viewed on that disc, does it appear to be edited or altered or in any way different from the events of that night?
No.
Your Honor, at this time the state would move to admit Exhibit A into evidence and publish.
Objections?
No objection, Your Honor.
Let me know when you're ready, Mr. Gomez.
I'm going to try to get the video up and started. I'm having to use a disk drive, so it does take a little bit longer. I think I'm ready, Your Honor. Officer, is this the information that you get relayed, the screen where you get relayed information about the dispatch call?
It is. One there, but I'm not seeing, I don't hear anybody.
Hey, 4 Mile Beach Police Department, open the door now for a ticket. Open the door now. Show me your hands. Show me your hands. Get out of here now. What are you doing? Get out of here. Get up off the ground, put your hands in the air. Straight in the air, stop. Turn around. Stop. Do not move. Do you understand me? Is there anybody else in this house? Who? Come out with your hands up. Who else is in the house? Are you the last one? Stand up, turn around, keep your hands in the air, you understand? Listen to me, if you just listen to me, I will ensure your safety, you understand? Come to the doorway, turn around, put your hands in the air, and stay right there. Okay, is everybody good? Do not move. We gotta go leave them. Just put it down.
Just stay right here. It's okay. Breathe. Keep your hands up just like that, okay? Stay just like that. Don't move. Don't move. Stay right there.
I want you to sit right here, okay? Relax. Any weapons on you? Step it off and check real quick. Sit down, please, okay? You good and calm?
This is you? Okay, what I want you to do.
It's all right.
Okay,
Relax.
it's fine.
Hands up, remember? Hands up, turn around. Walk back to the side of my voice.
Be careful. Take your time. Take your time. It's all right.
Like I said, just keep calm. Stop where you're at. Put your hands behind your back. Put your palms together. All right, relax, okay? Nothing's gonna happen to you.
Stay over there. We got it.
I'll explain everything in just a minute, okay? But obviously, we're not here for no reason. Move your march, okay? All right, come back. Any weapons on? No, sir. No, sir. We're just in the house. Just in the hallway. Yes, sir. You sit right there. Get your hips.
You good?
I'm good. Do me a favor for anything? Just until I can figure out what's going on, alright? I know it's not for a while. All right. Listen, real quick, we're going to talk to everybody separately. 135, 131, and 10-6. If you could head this way, break 4 walls, let me show 4 detained.
Officer Odoki, we saw in the video you patted down an individual in a white shirt. Who was that individual?
Mr. Pooley?
And then we also saw that you patted down an individual in a black jacket, I believe. Who was that individual? Do you remember?
I don't recall his name.
But is it safe to say neither of those individuals were the actual suspect?
Correct.
During your investigation, did you actually have an opportunity to speak to the 911 caller?
I don't recall.
To your knowledge, was there ever a written statement provided
Yes.
by the 911 caller?
Yes.
I have no further questions for this witness at this time around.
Mr. Nopes, you wish to inquire?
So, officer, you would agree that when you got there to begin with, you heard nothing as you approached the apartment the first time?
Correct.
And from that point, you turned around, and what your video shows, you walked back to your car and waited for backup. Is that a fair statement?
Yes, sir.
And then I guess you were told that the 911 caller apparently indicated to dispatch that he, meaning the caller, still heard someone demanding money from the occupants. Is that correct?
Demanding something, yes.
And the second time you went back to the room, the door of the room, did you hear anybody demanding money?
I couldn't hear exactly what was being said.
Did you hear anybody demand anything?
I couldn't make out what was being said, no.
So the caller was supposed to be where?
In the room next to them.
And in fact, at that point in time, I guess, dispatch didn't know specifically who the caller was, right?
They did.
What did they know?
Who called?
Well, all the report says is that the caller was named Brian, right?
Correct.
Not Brian Jones, not Brian Smith, not Brian whoever. It just said someone named Brian.
I don't know what the recording was when they took the first call. I know what was inputted into the call card.
Now, tell me about the door being either partially opened or how that happened.
So initially, when I had my hand on the door, because of the ease of opening it, I believed it was partially open, like not latched. Upon observing an additional body camera angle, it appears the door was closed, but not latched. Because like I said, I was able to push it with little effort.
Okay, so did you have to turn the handle?
Slightly, yes.
Okay, to allow entry.
Correct.
And at that point in time, you couldn't hear that anything in the nature of illegality, being illegal, was happening, right?
I could hear what sounded like a female in distress.
Okay. And so basically, you didn't have a warrant to go into the room. Is that a fair statement?
No,
That's not a fair statement?
I did not. It was a fair statement. I did not have a warrant to go in the room.
And so you basically went into the room without a warrant, and then I think the date was February. There's actually, the one report says February 6th, one says 7th, and one says 8th. I don't know what day it happened, I mean, for sure, but it was early February of 2024, right?
Correct.
Was it cold outside?
It was.
Okay. So I know one of the things that you put in your report is that my client was wearing a hoodie, I guess, coverings over his head and face.
Correct.
So when it's cold outside, is that
Inside your house it is, yes.
Well, what was the temperature inside the house?
I don't know what the exact temperature was, but most people don't wear that inside a house.
Okay. So as far as, I guess, once Mr. Moore got out of the room, did you see him in possession of a firearm?
Once he was out of the room, no.
Okay. Did you see him, did he do anything to resist?
Besides pushing the door back after I announced for his law enforcement.
Okay. So you're sure there wasn't one of these other individuals maybe pushing against the door?
No, they were all on the other side of the room.
All right. And it seemed like there was a bunch of clutter in that room. I guess we're calling it a residence, but really it's just a hotel room, isn't it?
Sure.
You're sure that some of the stuff that was god-awful amount of stuff in there wasn't somehow up against the door?
No.
How long did it take Mr. Moore to come out?
As far as
From the time you said, I want you to stand up and come out?
immediately.
Immediately?
Yes, sir.
Okay. Do you think maybe if he had been sitting in the floor or been in the floor when he stood up, he might have bumped up against the door accidentally as he's trying to get up and stand up?
He was standing up when I first observed him.
Okay. I think your report says that he was leaned down directly behind the door. He wasn't standing up when you first.
No, the other individuals were laying down in the room.
Okay. I'm going to hand you what's been marked. We'll hand you what's been marked as Exhibit A and tell me if you recognize this. Exhibit 1.
Yes.
What is that?
This is my report of this incident.
Okay. Did you see the part where it talks about your involvement with Mr. Moore? That's your first involvement?
Yes.
And doesn't it say that Mr. Devin Moore, wearing camouflage coverings over his head and face, leaned down directly behind the door?
Correct.
Okay, so he wasn't standing up when you first encountered him?
He was standing up, leaning. He wasn't laying, he was leaning.
Okay. As far as patting Mr. Moore down, did you do any pat down?
No, sir.
Okay. Who did the pat down?
Officer Houston?
Okay. And I think your report indicates that you got there, or I guess at approximately 2016. So what real time is, what is 2016?
8:16 in the evening.
Does your report or does the CAD report show exactly what time Mr. Moore was arrested?
It should, yes.
Do you have access to that?
Not with me.
How hard would that be for you to get the exact time that he was arrested?
If I could take a look on my phone, I may have it.
Judge, I may want to come back and visit how to receive that answer for this hearing. All right. Those are my questions. Your Honor, I will move the evidence what's been brought to Exhibit 1.
Objections?
No objection.
It's admitted.
I think that's it.
When you first approached, what apartment window did you first go up to?
Could you say that again?
What apartment window did you first go up to? when you
Apartment
first
1.
approached? So it was not the apartment in question?
Correct.
Okay. With respect to the caller, did dispatch know his location?
They did.
Where was that at?
Apartment 3.
So right next door to the apartment in question?
Correct.
When you opened the door, before you opened it, did somebody actually tell you open it?
Yes.
During your investigation, did you become aware of who was renting that room?
I don't recall.
To your knowledge, was the defendant renting that room?
No.
Where was the laundry basket that the gun was found in?
To the right side as soon as you enter the door?
So it was kind of behind the door?
Correct.
Was it in the proximity of where the defendant was leaning?
Absolutely.
I have no further questions for this witness at this time, Your Honor. He may be released.
Judge, I have one question.
All right, sir.
As it pertains to the caller being in apartment 3, you didn't find that out until sometime later. Is that correct?
I don't recall exactly at what point we found out that it was, but I knew, being there, that it wasn't the first one. I knew that it was going to be the one on the further side of it. I don't recall how that was relayed.
Those are my questions.
Can I ask a clarifying to that? Since you got it?
Yes, sir.
Okay. You just knew for sure that it was an apartment next to the one in question, correct?
Correct.
Okay. I have no further questions, Your Honor.
Is witness released?
State will release him.
That's fine, Judge.
Thank you.
Your Honor, at this time, the state would call Officer James Houston to testify.
All right, raise your right hand, please. And clerk, swear the witness.
Do you swear affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Please be seated and direct your voice to that microphone. Speak clearly and distinctly so we can all hear and understand you.
Good afternoon, officer. Thank you for being here. Can you please state your name for the record?
James Houston,
Where are you employed?
Fort Walton Beach Police Department.
What position are you in with the Fort Walton Beach Police Department?
Reserve Police Officer.
Were you working on February 6th of 2024?
Yes, sir.
Do you recall responding to an incident at 8 Gibson Place Northeast?
Yes.
Why did you respond there?
As a backup unit for a possible armed robbery.
What happened once you got there?
Once I got there, Officer Ordoki was at the door, or we walked up to the door, and you can hear commotion. I couldn't hear what was said, and I saw Officer Ordoki open the door, and when he pushed it open, it came back, and that's when he announced again, Officer Fort Walton Beach Police Department, open the door, or we're gonna kick it in. And then the door opened.
When the door opened, what did you observe, I guess, or what did you see when the door opened?
When the door opened, I walked up because I was kind of standing back. And when I walked up, the suspect was at the doorway. He was standing up at the doorway. And I pulled him out, took him out. There's a fence across from the doorway. Put him over there, put him in handcuffs. Then we walked up to it was like a picnic table area. That's when I patted him down.
After you patted him down, what happened?
I was gonna walk back over to the apartment, but they told me they had it to stay with the suspect. And as I was standing with the suspect, then they told me, okay, they acknowledged that he was the one that did the alleged robbery. And that's when I searched him.
Who is that? Who told you that he did the alleged robbery?
Officer Odoki and Officer Snot.
After you were told this, that Mr. Moore was the one who was identified as committing the suspected robbery, what did you do?
I patted him down, and when I patted him down, I found a baggie of a bluish powdery substance in the baggie, a phone, and also some metal object.
When did you feel like you developed probable cause to arrest Mr. Moore?
Once Ordoki established that he was the one that was committed, that's when probable cause was established.
Did any of the witnesses identify Mr. Moore as the individual who had robbed him?
Yes.
Did you search him after those witnesses identified him?
Yes.
Were you wearing a body-worn camera that day?
Yes.
Your Honor, may I approach?
Yes.
I'm handing you what is marked as State's Exhibit B. Do you recognize what I just handed you?
Yes.
What is that?
It's a DVD of a video that you showed me.
Did you view the video that was on the exact video that was on that disc?
Yes, sir.
Okay. Does it appear to be edited or altered or in any way different from the events of that night?
No.
Your Honor, at this time, the state would move to admit Exhibit B into evidence and to publish it at this time.
No objection, Your Honor.
It's admitted.
think we're ready, Your Honor.
Hey, Fort Walton Beach Police Department, open the door now before we kick it. Open the door now. Show me your hands. Show me your hands. Get out of here now. What are you doing? Get out of here, sir. Stop. Yeah, hang on. Stop. Hey, touch to them. You're not going to have Stop. Turn around. What am I getting wrong? Stop. Don't pull away. You're trying to figure out that now. Stop turning. Stop turning. What's our gun before? You got something there?
Safety reasons. You're detained right now. You're not under arrest. All right. Yep.
Stop. Oh, I'm explaining to you. You hear what's going on? Somebody saying you robbed. No. That's all I know. Do me a favor. You want to have a seat over here, okay?
Stay right there.
Sit down on this bench. You got anything on this will get you in trouble. Okay, stand for me.
What am I being searched for? I don't have much on.
Because you can't see you robbed.
No, what's that right there?
How we get it? Let's tell. What is it? Can I look?
No, sir.
I don't know that. Like I told you, somebody said you was bothering me. We gonna figure this out, all right? Have a seat. Just hang tight for me, okay? Hang tight.
Stay down there.
Okay.
Why you going to jail? Like, what's up?
I'll tell you what, I'm gonna say it one more time. Calm down. Somebody said they was being robbed. And that apartment, stop. I'm just telling you, you asked me what was going on, correct? I'm explaining to you. Right now, all we know is somebody said they was being robbed. Okay? That's all I know. So right now, we're gonna take it from there, okay? What's your name? Okay. Anytime?
Walk home.
Anytime? You have a driver's license?
No, sir. ID.
You have anything on it?
No, sir. Where my name on paper.
Okay, what's your first name? Spell it for me.
D-E-O-N-M-O-R-E.
What?
D-E-O-N-M-O-R-E.
D-E-V-O-N-M-O-R-E. What's your middle initial?
King Marcus. M.
Last name? Who?
M-O-R-E. You can take it on my face right now.
Oh, your first name is Devon.
Yes, sir.
And your last name is Moore.
Hey, you lying, man.
Stop.
No, I ain't got no fucking gun.
Stop.
Got no fucking gun.
Stop.
Yeah, you pat me down.
You say you got a firearm?
No, I don't. No.
Okay, so now I'm gonna search it.
What am I
gonna do? Don't reach in the pocket. I'm trying to tell you that.
No, there's not no gun in here.
How many times I tell you? Stop.
You know there's not no gun.
Stop. I don't know what you got in your pockets.
I don't know.
Stop.
Can you feel that some of this guy out? I
Okay, what's that? Ain't no gun. Stop. Ain't no gun though, that's what y'all here for. What's that? I don't know. I don't know, sir. I ain't said what's that? You got anything that's gonna get you in trouble? No, sir. You got anything gonna stick before me? No, sir. What is that? I didn't say it was done. Why the fuck you lying? That's for you to do. Okay, have a seat.
Did the defendant ask you to remove his face covering when he was outside?
I believe he did.
When you went to search Mr. Moore, do you believe you had probable cause to arrest him for robbery at that time?
Yes, based on what Officer Ordoki and Officer Snot relayed to me.
I have no further questions for the witness at this time right now.
And I apologize, but I need to take a comfort break at this point in time. We'll just take 5 minutes. 5 minutes.
All right.
is back in session.
Seated. All right, you may inquire.
So, Officer Houston, what time did you actually arrest Mr. Moore?
No, I myself didn't arrest him, it was Officer Ordoki.
Okay. So help me understand, if I showed you your CAD report, would you be able to look at it and tell me if it shows what time he was arrested?
If they called in the 10:15 time or show this person under arrest, it should be in there.
Because I'm gonna mark this as Exhibit 2.
All right.
May I approach the witness, Your Honor?
Granted.
I'm unable to locate the actual arrest time.
I'm sorry?
I said I'm unable to locate the actual arrest time.
Okay. Yes, I marked this as Exhibit 2. From watching the video, and I think you initially told the prosecutor that you initially patted him down, and we saw that. You said that he was standing at the door, and that you walked him out and patted him down, and we saw that. But then the next thing that was asked was something along the lines of, basically, when did you search him? And it was something your answer was something along the lines of, once they told me that he was the alleged suspect. And I'm assuming the rest of the sentence would have been the alleged suspect of the robbery. Then at the end of the video, what I heard someone say, and I'm assuming it was your main officer that was there, was that they found a gun. Is that what was said?
Something along the line of a gun was involved or used.
Okay, so
I can't recall if they said he had the gun or they found the gun.
Okay.
I can't recall.
But they had not fully interviewed these folks at that point, had they?
I don't know. I wasn't over there with them at the time.
Looking at the times, it looks like that the knock at the door was 20:22 and 9 seconds. And on the video, I looked up immediately when I heard you say what you said to my client, and it looked like it was 20:24 and something. And I guess we'd have to run it back to see exactly how long of a minute, how many seconds had passed. But that's only 6 minutes, or no, 22 to 24, that's 2 minutes basically, maybe 3 minutes since they getting everybody handcuffed and pulled out. But do you remember what you said when you told him I thought you said they found a gun, now I'm going to search you. Is that what you said?
I was told that a gun was involved or they had a gun. So I said, now I'm gonna search you.
Okay. But at that point, you didn't have probable cause to arrest him for robbery, did you?
Yes, because the victim said that he was the alleged.
But that's not what your other officer, your fellow officer didn't holler out. He's the one that they're telling me robbed them with a gun. That's not what was said.
Correct. And once they established that a gun was involved, whether or not they located the gun in the apartment, I didn't know. So I didn't know if it was still on him or not.
Okay, but at that point in time, you didn't have probable cause to arrest him for possessing a gun, did you?
I didn't arrest him. I wasn't.
But you said that you searched him because they found a gun.
Who found the gun?
Well, I swear that's what the officer hollered back, and that's when you said they found a gun, now I'm going to search you. So that's the operative time that you believe you have probable cause to arrest, to justify the search.
Probable cause I believe, to search him.
Right. But in order to search him, you have to have probable cause to arrest him. Just because they found a gun, officer, do you believe that if they found a gun in that apartment, that then you get to search everybody that's been in that apartment?
No. When they said, we found the gun, and I said, okay, now I can arrest, now I can search you.
Based on, for what? What crime had he committed?
Suspicion of armed robbery or home invasion.
But they didn't say that he was the one holding the gun. They didn't say, the officer didn't holler back, yeah, they say he's the one who had the gun and that he robbed them.
I believe they said that he was the one.
But isn't search incident to a lawful arrest, isn't that done after you inform him or let him know he's being arrested? Because it's a search incident to lawful arrest. So you're telling me you didn't arrest him?
I didn't arrest him. I was not the case officer. I was going off of Odoki, or Officer Odoki.
Right? So if your search was based on the fact that he was lawfully arrested, he had not been arrested yet. Would you agree with that?
No.
No? Did you arrest him?
I didn't arrest him, no.
Okay, did your other fellow officer, did he stop what he was doing and turn around and said arrest him? Based on what I know, we've got probable cause to arrest him, and you say, okay, I'll do it because he told me to?
Yes.
But that's not what we heard on the video, officer. And you just told me you didn't arrest him.
You have a case officer, and then you have backup. The case officer is the one that makes the choice of the arrest, not the backup. Do you understand? Or?
Well, I understand, I think, what you're saying, but then you've been telling me that you didn't arrest him at all, under any circumstance.
I didn't, no.
Okay.
I did not place him under arrest. I did not, no. But I am not the primary officer who made that decision. When we show up on scene, there's a primary officer or a case officer, then you have backup. as a backup, I'm following the lead of the primary officer. If the primary officer is like, okay, he's the one, the victims are saying he's the one that robbed him, and we have a gun, at that point, I'm assuming he's under arrest.
You assumed he was under arrest.
I'm not the one that's arresting him.
So you assumed he was under arrest, so therefore you
Based
had
off
the
of
right to
what,
search him.
based off of what the primary officer told me, or
He didn't come back and tell you anything. He hollered something back at you, and then you said, now I'm gonna search you.
right, because he's been identified as the suspect committing the crime.
Okay. Do you remember what you specifically said before you told my client, now I'm going to search you? Because I wrote down, they found a gun, now I'm going to search you.
Correct.
Is that what you said?
If the video says, shows it, or says, then that's what I said.
Those are my questions, Your Honor.
Redirect.
Kind of alluded to, would the video be the best evidence of what occurred that night?
Yes.
So if the video showed the victim and the witness identifying the defendant as the one who was possessing the weapon, the video would be the best evidence?
Yes.
If the video showed the defendant responding to those witness allegations and the victim allegations in an aggressive manner, would that be the best evidence?
Yes.
No further questions, Your Honor.
Witness released.
Yes, Your Honor.
Judge, I did mean to ask one question.
Okay.
The drugs in this case, officer, that he's charged with trafficking the fentanyl, when all that happened right there at the end of the video, did you seize those drugs then? Are those the ones that he's being charged with? When you said, I think you said, they found a gun, so now I'm going to search you. I do know you said, now I'm going to search you.
Correct.
Did you find the drugs at that point?
Yes.
Those are the ones he's charged with?
Those are the one I pulled out of his front pouch of his thing.
Those are my questions.
Witness released.
Yes, Your Honor.
That's fine with me, Judge.
Thank you very much. Good day. Anything else?
No evidence from the state. No further evidence from the state, Your Honor.
No evidence, Your Honor.
Thank you, Your Honor. Much of this motion, particularly in the memorandum of law, centers really around one primary case, and that is Baptiste versus State. That site is 995 Southern 2nd 285, and it's a Florida 2008 case. In that case, Your Honor, the facts are that the officer received a dispatch call about an anonymous caller reporting a black male wearing a white t-shirt and blue jean shorts, waving a firearm in front of a grocery store. When officers arrived, when the officer Ellison arrived, another officer had already detained the male at gunpoint. They ordered the individual to lay on the ground. A citizen approached the officer and said that he was the anonymous caller and he intended to remain anonymous. The defendant then advised that he was in possession of a firearm. The court in that case stated that other than the gender, the record provides no additional information, and actually go on to say such as name, age, address, or appearance, with regard to the anonymous caller, and that anonymous caller was never further identified. In the court's analysis, there's a couple of statements that I want to point out because I think it's pretty important when we're looking at the facts that we're dealing with. An unverified tip from a known informant might not be reliable enough to establish probable cause, but nevertheless is sufficiently reliable to justify a Terry stop. One who qualifies as the latter type of individual, sometimes referred to as a citizen informant, is more deserving of presumption of reliability than the informant from the criminal milieu. They then go on to look at another Florida Supreme Court case in Florida versus JL, which is 529 U.S. 266, and it's actually, a Supreme Court case. In JL, an anonymous caller informed the Miami-Dade police that a young black male was standing at a particular bus stop and wearing a plaid shirt and was carrying a gun. Officers observed the individual who matched the description. The officers ordered JL to place his hands on the bus stop sign. They frisked him and they seized a firearm. The court, with respect to the JL case, stated that unlike the detective in Terry, the officers in JL had not observed any illegal activity, unusual conduct, or suspicious behavior. The court noted that prior to the search, the officer's suspicion that JL was carrying a firearm was not generated by observations of the officers themselves, but instead solely by virtue of the anonymous call. After their analysis of JL, they looked to the case that they had at hand, so we're back to the Baptiste fact pattern. They said, it is clear from the record of the suppression hearing that there was no evidence that the officers at the scene observed or confirmed any illegal activity, unusual conduct, or suspicious behavior to indicate that Baptiste was carrying a firearm before Officer Williams stopped Baptiste at gunpoint and these events transpired. Critically, the court actually goes into, in the Baptiste case, how the actual officer that detained Baptiste in that case, there was no evidence whatsoever at the suppression hearing that they even had knowledge of the dispatch call. And so the court made note of that. They said, given both the lack of record evidence with regard to the information which was conveyed to Officer Williams and the fact that there was no evidence or mention of these witnesses either during the suppression hearing or in the lower court's decisions, we must work with the evidence from the suppression hearing that no one had informed the responding officers that Baptiste had waved a firearm before the stop at gunpoint. Further, Baptiste was not engaged in any unlawful acts, unusual conduct, or suspicious behavior. He was merely walking down the street. They then go on to say, this analysis, however, does not lead to a conclusion that an anonymous tip, such as provided in the instant case, can never provide reasonable suspicion under a totality of the circumstances analysis, nor does it preclude officers from approaching a citizen and making an inquiry. Further, nervous behavior of a suspect upon the approach of an officer, when considered in conjunction with a purely anonymous tip, may, under the totality of circumstances, establish reasonable suspicion for an investigative stop. Here, the record does not reflect any additional circumstances or facts which might have established a reasonable suspicion. At best, when the officer first observed Baptiste, he was merely walking down the street, not running away from the grocery store or engaged in any suspicious conduct. I think that's important. The Baptiste court then also looked at a case, U.S. versus Perkins, which is 363 F3D, so Federal 3rd, 317, it's the Fourth Circuit in 2004, and distinguished it from the Baptiste case, importantly stating, the Perkins tipster lived across the street from the address where the events in question were reported, and she had provided reliable information in the past. In concluding that the stop in Perkins was legal, the federal court specifically stated it had conducted a totality of the circumstances analysis and cited a number of these qualitatively and quantitatively different factors in support of its conclusion. The facts of Perkins were that in May of 2002, an unidentified woman called the police department and reported that there were two white males in the front yard of a duplex at an avenue who were pointing and displaying rifles in various directions. She further reported that the men had arrived in a red car bearing a silver or white stripe. The officer at that time who responded believed that the woman lived across the street based on the detailed nature of the caller's description of the individuals and their conduct, which revealed that she was in close proximity to them. Officers later confirmed that it was an individual who had reported information to the police in the past, but this was after the initial detention and arrest of the defendant. The defendant in Perkins made similar arguments as the defendant is making here. Perkins claims that the tip could not form the basis for an investigatory stop, and Officer Burdett could not possess reasonable suspicion to stop Perkins' vehicle. The court responded to that and said, as an initial matter, it is not even clear whether this is a purely anonymous tip. It obviously had some characteristics of an anonymous tip because the woman did not give her name to the dispatcher. Even if the tip is deemed anonymous, we still conclude that the Officer Burdett had reasonable suspicion to stop the Perkins vehicle. In the present case, by contrast, Officer Burdett did not rely solely upon a call made by an unknown person from an unknown location. Quite the opposite. The caller revealed her general location and her basis of knowledge as the nature and substance of her tip made clear that she was in close proximity to the men that she was observing while she had them on the phone. And I think this is important. For in reality, tips fall somewhere on a spectrum of reliability. And under the Fourth Amendment, a reviewing court may, indeed must, take into account all the facts surrounding a tip in assessing the totality of the circumstances supporting a stop. As noted from the cases discussed, had Baptiste appeared, so they go back to Baptiste. As noted from the cases discussed, had Baptiste appeared nervous, reached for his waistband, fled, or engaged in illegal or suspicious conduct, these ensuing events, depending on the totality of the circumstances, might have established reasonable suspicion for the officers to stop and frisk Baptiste. So I think first, and much of this, I would say 4 or 5 pages of this hinges on really what we classify the caller as. At least that's the argument that's made in the memorandum of law. The defense wants to argue that this is an anonymous caller. But if you look at the cases that the defense cited in Baptiste, and then the defense cases cited in Perkins, and as well as in JL, this is something much more than an anonymous caller. We have his first name, we have his location, and unlike in Perkins, or similar to Perkins, and unlike in JL, the caller is actively on the phone as law enforcement is approaching the window or the apartment. And even when the officer goes back, dispatch notifies him, like, the caller is still on the line, he is still hearing these things. And then once the officer approaches the correct door, he then also begins to hear a commotion. I think one of the specific phrases that he used was a female whimper. And then he also heard a loud commotion. Simply put, the Baptiste case is not the same as in our case. Unlike in JL, which was cited in the Baptiste case, the Leos in our case did observe more than just a 911 call. The officers observed this suspicious behavior. Upon approach, Officer Ordoki heard what he described as whimpering and yelling upon his second approach. He then knocked on the door with no answer. That in and of itself is suspicious because he knows that there are people inside of that residence because upon approach he heard the whimpering and he heard the yelling. He also has a 911 caller who is on the other side of the wall, which the state would argue is likely thinner than a door or a brick wall, telling him that, hey, there's still this commotion going on. I think at one point in time he heard, give me what you have, or I don't have anything for you. Those are pretty specific words to develop the accusation that a robbery is occurring. Upon attempting to open the door, the unlocked door, Officer Ordoki testified that he heard somebody say, open it. And then when he did try to open it, he was met with resistance by the person directly behind the door. Once Officer Ordoki was able to actually gain entry into the apartment, the defendant was wearing a face covering and was reaching down behind the door. That is wearing a face covering indoors is the definition of suspicious behavior, especially when you couple it with the fact that when you go and watch the video where he's talking to Officer Houston, outside where it's actually cold, he asks him to remove the face covering.
So he could hear me.
This is much more than just an anonymous tip. This is a 911 caller that was actually identified and gave a written statement after the investigation happened. Law enforcement officers in a situation where an active robbery has taken place can't take the can't risk going and speaking to a 911 caller that they know is in proximity and risk not providing aid to somebody who could potentially be in a very dangerous situation of getting robbed. So under the totality of the circumstances, the call, coupled with the observations of the law enforcement officers on scene, gave reasonable suspicion to detain. And I would also point out that we saw the law enforcement officers were outnumbered. They didn't just detain the defendant. They put every single individual, including the to-be-known victim, in handcuffs and separated them and pat down every single one of them to make sure that everybody was safe. Once we heard testimony, Officer Houston patted him down. Once Officer Houston heard, and we saw in the video shows that both a witness and a victim stated that the defendant was the individual who possessed a gun and was robbing them. At that moment, the defendant actually responds. He responds to them, indicating they were the ones that identified him. At that moment, the state argues that at that moment, probable cause had been developed to arrest him for armed robbery, or at least robbery, not armed at that point, but robbery. And so any search that would have happened after that individual was identified was valid because they had probable. Which kind of leads me to my next point, inevitable discovery. In Key versus State, 311 Southern 3rd, 1007, Florida 1st DCA 2021. In this case, the law enforcement officer observed the defendant traveling in a continuous left median lane for about 250 feet before turning left. He was pulled over. Both law enforcement officers stated that they observed the defendant appearing extremely nervous when they approached the vehicle. While looking for his information, both law enforcement officers observed a cell phone on the defendant's leg. That cell phone had a picture on it showing a large quantity of methamphetamine on a scale. The law enforcement officer asked the defendant to get out of the vehicle. The defendant consented to a pat down, and the law enforcement officer handcuffed the defendant and placed him in the back of his patrol car while preparing a traffic warning. While doing so, the K-9 was ran and alerted on the vehicle. They searched the vehicle and found narcotics and paraphernalia. In their analysis, the court found that the defendant to have been placed under arrest was placed under the arrest when law enforcement lacked probable cause. However, evidence obtained as the result of unconstitutional police procedure may still be admissible provided the evidence would ultimately have been discovered by legal means. And that's at 1011 in that Key versus State case. The court found that Officer Kuhn would have conducted a canine search of the vehicle while the other Leo was writing the traffic warning had the defendant been detained or not. The only change that would have occurred had there not been an illegal detention was that the appellate would have not been handcuffed in the back of the patrol car during the search. Thus, the discovery of the drugs and paraphernalia was inevitable, and the fact that the de facto arrest occurred prior to the officers having probable cause is irrelevant. Now, I cite that not to concede that there was not reasonable suspicion or that the law enforcement officers lacked probable cause, but to show that even if this court finds that they did, they would have inevitably discovered the contents and they would have inevitably searched the defendant incident to arrest. We heard Officer Ordoki, and this was the reason why I elicited this testimony, that once they actually do an investigation, they find a gun in the exact place that the defendant was reaching. They find a bag full of the victim's belongings, to include a PlayStation 5 and a pair of Jordans, right where the defendant was at upon opening the door. The defendant was wearing a face mask. Multiple of the witnesses and the victim identified the defendant as being the individual who was robbing them. He would have inevitably been arrested, and he would have inevitably been searched incident to arrest, regardless of whether or not they had probable cause to do it at the moment that Officer Houston did. Your Honor, given all of this, the state respectfully requests that you deny the defendant's motion to suppress and allow this case to proceed forward. Thank you.
Mr. Knox.
Your Honor, the motion, the motion to suppress originally filed, and then the amended motion are basically identical. I made just a couple of clerical errors as to the charges that he was against him, and then I think I added the actual site to the Batiste case, but in essence, the motion to suppress, the original motion to suppress and the amended, the basic arguments, I think the court can see they're set forth pretty clear as to the reasoning behind them. What I'd like to basically focus on is at the time Mr. Moore was seized, basically detained. He was told to come out of the apartment, and he did. He was handcuffed. So at that point in time, he is seized. He's being detained. Clearly, you saw the video, Your Honor, he wasn't free to leave. He wasn't allowed to do whatever he wanted to do. He's seized at that point in time. And all they had at that point in time was a 911 call in which the caller indicated that he suspected or believed his neighbor may be the subject of a robbery. And the initial responding officer reported that he knocked on the door and did not immediately see or hear a disturbance. So the first task in determining whether the reasonable suspicion exists is the determination of whether the 911 caller can be classified as an anonymous tipster or citizen informant. You know, basically the law is that based on what information they had about the caller at that point, I think at best he is an anonymous tip, basically, because they hadn't gotten his full name. And I don't necessarily know at that point they had his full address and where, you know, what his full address was. They really, you know, I guess they may have had a phone number. But having said that, the bigger issue, Judge, that we have is that Officer Houston, and I think the video's been admitted so the court can review it at your leisure, but I think, and this is within 2-3, I don't think any longer than 4 minutes of when they started, got Mr. Moore out, and then they started handcuffing the others, having them come out and sit down, and no interview had been started yet that I could tell. Of course, the problem is it'd be nice if we had somebody standing on the sideline that videotaped the whole thing. As you can get the big picture, you can get everybody and the timing of how it goes down. But Judge, he basically said they found the gun. Now I'm going to search you. And if that is exactly what was said, then what were they arresting him for? The finding of a gun in and of itself doesn't prove anything. You know, even at that point, for Houston to make that statement, he doesn't know the rest of the information that the first officer had, which is that he saw the guy leaning down when he first laid eyes on him, when the door was opening.
But again, finding a gun in and of itself is it's not a crime for somebody to be in a residence or in a room or whatever, and later the gun's found in it. That doesn't necessarily in and of itself describe a crime. So, but the officer was adamant that in that video that, and again, I may have not heard him correctly. Hearing's not one of my best talents, but the second part of it was, I think he said they found a gun, and then specifically he said, now I'm going to search you. For whatever the first part of the statement was, that was his reasoning to let my guy know, now I'm going to search you. At that point in time, I don't believe that anybody had enough at that point in time to form probable cause to arrest my client for anything. And therefore, anything that was taken from Mr. Moore at that point in time, and he did testify that the drugs that he's charged with in this case, in fact, that they were found at that moment of that video. And so I just don't know that there was enough facts known to justify his arrest at that point in time to then otherwise justify the search incident to a lawful arrest. So we'd ask the court to suppress the evidence in this case.
Any rebuttal?
None, Your Honor.
All right. So, listening to the arguments and reading the motion and watching the videos, it's, in my mind, it's all the different rules sort of colliding together in that one moment, right? In that one set of circumstances. I didn't look at the elapsed time, but between the time that the video starts with Officer Odoki and getting there, and it was mere minutes. It wasn't a half an hour. I mean, it was mere minutes. And like I said, in my mind, all these rules collide together. And some of the rules regarding investigatory stops also involve the question that is here, which is whether or not the entry into the house may have been based upon exigent circumstances, because the rules talking about what constitutes exigent circumstances have some of the same basis of the Terry stop rules, and that's most of the cases y'all are arguing are having to do with Terry stops, right? But the circumstances are the same. And let's talk first with the question about the tip. One of my favorite older cases is, well, I guess I shouldn't say that. That kind of dates me, doesn't it? It's a 1972 case, probably older than a lot of people in the courtroom, but I guess I can say that one with my age. But what I like with Mr. Justice Rehnquist's opinion there, which on, I believe that's at the bottom of page 147, which is 407 U.S. 143, or yeah, and that's at bottom of 147. One simple rule will not cover every situation. Some tips completely lacking in indicia of reliability would either warrant no police response or require further investigation before a forcible stop of a suspect would be authorized. But in some situations, for example, when the victim of a street crime seeks immediate police aid and gives a description of his assailant, or when credible informant warns of a specific impending crime, the subtleties of the hearsay rule should not thwart an appropriate police response. And then that case carries over into quite an interesting case from the first DCA, which is Berry versus State, found at 86 Southern 3rd, 595, an opinion by Van Nortwick. There is a concurring opinion, and interesting enough, a dissent by Judge Swanson, who remembers was a circuit court judge here for a while. If we then read what that opinion says, what I particularly like about that opinion, at the in the middle of page 598, the spectrum of reliability of a tip ranges from the anonymous unknown tipster, whose assertions of criminal activity typically cannot be verified and thus require independent corroboration, which has a relatively low reliability, to the relatively high reliability of a tip from a citizen informer crime victim whose motivation in reporting illegality is the promotion of justice and public safety rather than financial gain, and who can be held accountable for the accuracy of the information given. I'll omit the citations for brevity. In between these types of tips is the face-to-face anonymous tipster whose identity cannot be ascertained, the face-to-face anonymous tipster whose identity is ascertainable, and the paid informant, among others, and then the citation to Adams. One simple rule does not comply with every set of circumstances. So what we have here is what activated the response of the officer in this case is a phone call from someone who says, I'm next door, I'm hearing this, and to not judge the circumstances, I'm just going to call it a kerfuffle. I hear a kerfuffle next door, I believe there's criminal activity, and stays on the phone with dispatch while the officer responds. Now, notwithstanding modern communications, the officer goes to the wrong place and doesn't hear any kerfuffle. Goes back to his car and is told the caller's still on the phone. The caller still reports the kerfuffle going on. The officer goes back, now hears a whimpering woman, a woman in distress, and some other loud noise. I can kind of hear it on the video. I can't distinctly understand any words that are being said. And I know there's some dispute about whether the doorknob was turned or whether the door was latched or whether the door was open. We heard the testimony, opened the door is what came from the inside was the testimony. So the combination of those circumstances, so even if this was truly a fully anonymous tip, the officer arriving, hearing the kerfuffle from the inside, and acting upon it would be sufficient for those circumstances. Watching what happened on the video then, in the point of view of the officer and the circumstances, They removed everybody. They secured everybody involved and began their investigation at that point. Now, I can't hear specifically the words heard, but in the background of Investigator Houston's video, you can see there begins the passions of the defendant are inflamed by a comment made by someone else off camera, and he bows up a little bit to deny those allegations, and within that is the words, he has a gun or he had a gun. And it's at that point that then the physical search of the defendant occurs. So given the totality of those circumstances and the situation in which the officers found themselves, first, the court finds that the response of the officers to the unit involved was not based upon a fully anonymous tip. The identity of the caller could be ascertained, or the reliability of the tip could be ascertained based upon the physical proximity to the circumstances occurring. Although at first the officer couldn't verify it because he was at the wrong unit, when he went back to the other unit, he could verify those circumstances by his own physical sensation of hearing the kerfuffle himself, which was consistent with what had been reported. His engagement with the people inside and the response he had reinforced that and legitimized his engagement with the people inside and what he did. Removing the people from the unit was proper under the circumstances presented based upon the court's view of the video and the totality of the circumstances. And it's clear the defendant was not searched until this situation with he had a gun, he has a gun was stated, at which time Investigator Houston said, "I will now search you." And so given those sets of circumstances, the court finds it's not appropriate to suppress the search or the entry into the unit, and the motion will be denied. Do we want to set this for next cycle,